We have a minute until it's 8:30. So thanks for everyone for being here today. All right, we are live at the the Joint Agriculture, State and Public Lands and Water Resources Committee meeting in Torrington, Wyoming. Welcome to everyone in the audience and online. So we'll go ahead and call the roll.
This is roll call for Monday, June 5th for the Joint Ag, State and Public Lands and Water Resources Committee. Senator French.
Here.
Senator Hicks.
Here.
Senator Ide.
Here.
Senator Kolb.
Present.
Senator Larson.
Here.
Representative Allemand.
Present.
Representative Allred.
Here.
Representative Banks.
Here.
Representative Conrad.
Excuse.
Representative Crago.
Here.
Representative Davis.
Here.
Representative Slagle.
Present.
Representative Winter.
Here.
Chairman Steinmetz.
Here.
Chairman Eklund.
Here.
We have a quorum.
Thank you, Katie. All right, we're going to begin today with the Pledge of Allegiance, and then our good mayor from Torrington, Herb Doby, will lead us in an invocation and give us a welcome. So Representative Banks, would you lead us in the Pledge of Allegiance?
We thank you for all your great and many blessings, and especially at a time like this, we thank you for the blessing of a free country and a representative government, which allows us to keep the freedoms that you have bestowed upon us. I pray that you'll be with me today as I welcome this committee. I pray that you will be with each and every one of them in the work that they do. I pray that it will bless each and every citizen of this state, and I pray that it'll glorify you. Just help us all. We pray these things in Jesus' name. Amen.
Amen.
Thank you, Senator Steinmetz. Good morning and welcome to the city of Torrington. Thank you for allowing us to host your meeting. I'm Herb Doby, as I said, Mayor of Torrington. I'm a friend of Sherry Steinmetz, the senator, and she invited me to welcome you today. Recently, Mayor and Council proclaimed and recognized FFA Week. In doing that, I researched the data. In 2017, Goshen County had a gross ag revenue of $202 million and a net ag revenue of $37 million. Ag is our predominant industry. Torrington is blessed with the presence of Eastern Wyoming College and the Wyoming Medium Security Prison. But agriculture will be our revenue generator for the foreseeable future. For 90 years, we had the sugar processing plant. It is closed now. With the sugar plant, we added value to great crops of sugar beets while providing seasonal employment and great permanent employment for many families. Regarding state energy policies, I hope that with your influence in Cheyenne, we can get away from this renewables rabbit we are chasing and get back onto solid economic ground with the blessings we have in abundant coal, oil, and natural gas. I would like to see a modern clean coal or gas-fired electric power plant in Torrington, perhaps on the grounds of the old sugar factory. I hope through your influence on this committee, we might move off the false Green New Deal premise and get back onto fundamental economic security through agriculture and viable energy. Again, welcome to town. Please enjoy our shopping, our restaurants, golf course, swimming pool, parks, and ball fields. Thank you.
Thank you, Mayor Doby. We appreciate you being here and your service to our city.
Thank you, ma'am.
And I'd also like to recognize our college president, Dr. Haas, today. Thank you for inviting us to EWC to have our meeting. We appreciate you and and you hosting us today. Thank you. All right, with that, just a few housekeeping items. If you have a cell phone, please turn it to silent. Attendees, please sign in. And we will begin with taking up our interim committee rules. With that, you have a copy on the desk that was passed out to you today. The first page, we just have some changes to reflect how we run our committee with co-chairman through the interim. We don't have a chairman and a vice chairman. On page 2, the proposed change, and the two chairmen did work on this together. It would require a quorum for the joint interim committee to transact any business shall be a majority of the members from each house who are appointed to serve on the committee. That would be any business, a roll call vote to sponsor legislation to amend a bill or to conduct our business. However, on section 2, you will see that if there is not a majority of one house or another, then just a simple majority is all that would be required, and that's under subsection 2. We also talked about not allowing absentee voting, just for the simple fact that we feel like someone needs to be present and know what they're voting on. And so many times things change a lot during a committee meeting. So we'd like people to really understand the subject matter before they cast a vote. So that was something that Chairman Eklund and I had discussed. Do you have any remarks on the rules?
Yeah, Chairman Steinmetz, I've served both ways, been on committees where the rules, the House could overrule the Senate because we have more members. We've got 9 members, and normally the Senate would have 5, and we've got 6 this time. And only been accused of steamrolling the Senate once, and I don't think that was the intention of it. And I kind of like these rules because if we don't get a majority of consensus from both houses, we just as well kill it and move on and save the state some time and money. So I kind of like the rules written that way. I do have a question for the LSO that just kind of came up in my mind. We do not have to have a quorum, in other words, over 50% of the 15 members to be able to pass things then, according to these rules, I think. Because we used to have to have a quorum of the whole, both committees.
Well, you'd have to have, Mr. Chairman, you'd have to have a quorum of each house.
Okay, but if we don't, then it's a majority period, or is it a majority of what the quorum should be, which would be 8 members? We have 15 members.
You'd have, Mr. Chairman, you'd have to have, yeah, it would be a majority of the committee at that
Okay.
point. Yes,
All right.
you're right.
Yeah, I think that's the way we wanted it. Thank you.
All right, thank you, Mr. Chairman. So do I have a motion on the amendment to the rules?
Madam Chairman,
Yes, Senator Hicks.
if you'd be entertained, I'd like to have a little discussion.
Okay,
When it comes to absentee voting, I think a definitive that you can't vote probably should be reconsidered. We could oftentimes have situations where somebody can actually be very informed on an issue, and for whatever reason, their car broke down trying to get here, or they had a death in the family or whatever. I think that decision ought to be left with the discretion of the chairman on any particular issue. So if there's an issue that comes up and they've notified the chairman that I can't make it, but I've done my homework and all these issues, I think it's good business to allow those members that have put the time in and for whatever reason can't actually physically be in the meeting, work with the chairman. And if the chairman feel comfortable that member is what I would say well-informed on the issue and stuff, that it would leave it up to the discretion of the chairman as to whether on any particular issue that a member could vote absentee. And I think that's just better business for the legislature and those unforeseen circumstances that may arise in the future. But that would be my suggestion to amend that subsection E on absentee voting and say absentee voting shall be permitted at the discretion of the chairman. That would be my recommendation.
Okay, thank you for that. I think that procedurally, we need to move the
So Madam Chairman,
Document
I
first.
move the rules,
okay,
the joint rule.
it's been moved. Do I have a second? It's been moved and seconded. And now we can have discussion. There's been a proposed amendment to the rules. Is that a motion?
Madam Chairman, I would make that motion.
It's been moved. Is there a second?
Second.
It's been moved and seconded. Is there any discussion on the amendment?
Yeah, so it seems simple enough and it seems fair enough. But I think we kind of opened the door to just have allowing absentee voting. I think as a chairman, I would have a hard time telling one member that he isn't well enough informed on an issue. So I think leaving it as just absentee voting shall be permitted would probably be the way to do it, but I prefer that we don't do it that way because it could also encourage members to not show up for meetings, and that's happened before too.
And Madam
Further
Chairman,
discussion?
I
Senator
fully agree with that last statement. But if they've notified the chair and they're able to do their homework and make a recommendation as a vote on an issue, I hate to exclude duly elected members from their districts and their public from being able to cast a vote. If it's at the discretion of the chairman that they've met their obligations as a committee member and for whatever unforeseen circumstances that they cannot make the meeting, again, that would be at the sole discretion of the chairman to make that decision.
Go ahead, Senator Cole.
Thank you, Madam Chairman. I think I trust the chairman, and the chairman's discretion, I think, is appropriate in this case. There are going to be anything you make that's carte blanche is most likely not a very good rule because there's exceptions. But that's the job as a chairman, is to make those choices and those calls. Thank you.
Further discussion? Further discussion?
Madam Chairman,
Mr. Chairman.
I agree with mainly the last part of what Senator Hicks talked about, that we are duly elected, and I hate to take a person's vote away, but I don't know, it's hard to weigh out what would be better to have. Maybe encourage absentee voting. And I think the chairman should be able to make a good decision on it, but in order to appease their committeemen, most of the time they're going to allow absentee voting. And I think that's probably not the way we want to do it, but I'd be okay if we did it that way.
Mr. Chairman, I don't understand. Are you agreeing with Senator Hicks or are you opposing his?
I think I'll probably vote aye on it, but I'm kind of torn on it. I believe it'll create us.
All right, any further
Problems as well.
discussion? Further discussion on the amendment? All those in favor, please say aye.
Aye.
Opposed, no.
No.
Motion passes. We're back on the rules as amended. Is there any further discussion? Representative Craigo.
Thank you, Madam Chairman. I guess I just wanted to have a quick discussion about the quorum. Because the Senate has 6 members, a quorum is going to be 4 members, which is different than the standard 5, obviously. And so that's really a super majority on the Senate side to pass anything out of this committee. I mean, it's going to be a 2/3 vote requirement of this sitting Senate members of the committee. Whereas on the House side, it's only going to require a simple majority. And I was wondering if the Senate would be okay with us just amending that down to 3 members. I mean, it would seem more fair to me that instead of requiring a super majority on the Senate side to pass legislation out of committee, that it would just be the standard 3 members.
Okay. All right, is that a motion?
It is, Madam Chairman.
All right, do I have a second?
Second.
It's been moved and seconded. Discussion? I thought I saw
I-
someone's hand
I
up.
think we have an interesting, this discussion wouldn't normally take place. It would be 3 members
Yeah.
because normally we have 5 members on standing committees. So, but we have 6 senators in this case. So I think it's probably fair to allow the Senate to pass things on 3-member vote instead of 4.
So
Thank you, Mr. Chairman. Senator Cole.
Thank you, Madam Chairman. I'd like to commend Representative Crago for realizing the cram down exists. And thank you.
Madam Chairman,
Senator Hicks.
neither speaking for and against it, but it's not unprecedented. So the Select Water Committee has got 6 and 6. There's a number of select committees that it takes a supermajority of either one or both houses. Capital Finance Committee has 6 members from each, and it's a majority of either the committee or both houses based on those rules. So I'm ambivalent, but it's not unprecedented that we have require with some of the select committees that you have to have those at least 4 votes to move anything out of those committees, just for the committee's edification.
Representative Crago.
Thank you, Madam Chairman. So just a question for Senator Hicks. So is that, I believe on where it is a supermajority, it's supermajority on both sides and not one side or the other. I guess that's all I was trying to get to. I don't care if it's supermajority, as long as it's fair on both sides, House and Senate. It doesn't matter to me.
Right. All right. Well, and just to comment on it, I'm ambivalent as well. One of the thoughts is, if it's 3-3 in our committee, it will die on the Senate side. I mean, that's so a super majority doesn't hurt us in the long run. It might save us time.
This, Madam Chairman, if I understood the motion correctly, a 3 vote would be an aye vote.
That's right. And in this
A
committee,
3-3 tie would not be. Oh, boy. I can't remember how we do it in select water, but this is an unusual deal for the Ag Committee.
Well, 3-3 would
fail. It's a fail.
Okay, well,
Tie votes are a fail. And so we would be amending the normal, and if the whole
okay.
thought of this rule is to prevent wasted time and effort if we're going to have a bill that would fail in one house or the other. We were trying to avoid that. So that's just for consideration. I'm still ambivalent. Go ahead, Representative Crago.
Thank you, Madam Chairman. So your point's well taken that if it's a 3-3 tie here, when we get to session, it's going to die in theory anyways, unless somebody changes their mind.
Mhm.
Well taken. I'll withdraw the motion.
Thank you, Representative. I appreciate that. All right. Are there any further amendments or discussion on the rules? All right, seeing none, going once, going twice. All those in favor of the rules as amended, please say aye.
Aye.
Opposed, no. The rules have passed. Good job, everyone. We've got our first order of business taken care of. And we're on to our discussion about eminent domain. We will have our LSO staff come down and present the white paper that they have presented to us. We are trying to be efficient with our time. We know we have a lot of people who have traveled across the state, and as LSO comes down, we want to thank you for being with us today and taking time out of your busy schedules. I have a quote I want to read just really quick, because I think it kind of encapsulates. It says, "Leadership is not always about having the answer. It is about being willing to engage in the conversation and learn the answer together." And so I think that's what we're here to do today, and find solutions for our state and for our landowners and for everyone concerned. So with that, Anna,
Madam Chairman.
go ahead.
Madam Chairman, so I'd like to add a little bit while we're at the beginning of this, and it's for everybody, the committee as well as the public. We may get into some fairly long-winded conversations, and in most cases, I think people can communicate what they need to in a couple, 3 minutes. The most effective debaters I've ever seen are never at the mic for more than a couple minutes. And I think we can do it here, and it would help us to stay on schedule. So I know I don't think we're gonna carve it hard into rules or anything, but we may have to slow some people up with the talking if it gets too long-winded. And I've been in some committees that could have been cut short 2 hours earlier than they were because of too much talking. So anyway, I would appreciate that consideration from the committee as well as the public.
Thank you, Mr. Co-Chairman. That's a great reminder for us, and I think everyone will take that to heart today. So with that, Anna, would you please take us through the memo you provided for the committee?
Chairman, members of the committee, my name is Anna Johnson, also staff attorney. This committee requested an overview of the eminent domain process as it applies to wind energy collector systems. A wind energy collector system is a network of medium voltage cables that collects the energy generated by windmills and channels it to a substation. Eminent domain is the state's right and power to appropriate private property to promote the general welfare. Eminent domain occurs when, by the state's authority, a corporation, the state, or a private citizen takes another person's property for a particular use without the owner's consent. The Wyoming Constitution states that private property can be taken without the owner's consent to create, in part, private ways of necessity or for domestic purposes. The owners must be duly compensated. The Wyoming Eminent Domain Act addresses the ability of private individuals to involuntarily condemn property under eminent domains. Under Wyoming Statute 126-815A, this statute specifically addresses the eminent domain authority of electricity producers and transmission companies, and it provides for eminent domain authority to electric power transmission and distribution systems, which appears to include wind energy production companies. Wyoming Statute 126-815D was enacted in 2010 to prohibit the use of eminent domain for wind energy collector systems, except by a public utility with approval of the Public Service Commission. This moratorium ended in 2015. Legislation was proposed in 2018, 2019, and 2023 to extend the moratorium, but those efforts were unsuccessful. To utilize eminent domain, a wind energy company must first attempt to negotiate with landowners. And if negotiation fails, the wind energy company must show that the proposed project is in the public interest, balances the greatest public good with the least private injury, and the intended property is necessary for the project. If the court sides with the wind energy company, the company must provide the landowner with just compensation. Aside from eminent domain proceedings, wind energy organizations must also obtain a permit from the applicable county before erecting a wind farm. If categorized as a public utility, the permit must also be obtained from the PSC. And I would stand for any questions.
All right, committee, any questions for Anna? Questions for Anna? I do have one. Have we seen an actual use other than the use of saying they have the capacity to use eminent domain? Because in my mind, that is a use of eminent domain. Have we actually seen it used to take land by a wind farm?
I asked several different people and agencies. The only thing that I heard was that there was one county that commenced eminent domain proceedings, but not for wind collector systems.
All right,
So that's all I came up with. I apologize.
that's fine. Thank you for that. Senator Ide.
Thank you, Madam Chair. I'm not sure if this is the appropriate place to interject. You know, you mentioned that it would need to be in the public interest or, you know, the greatest public good. And I don't know if it's taken into consideration from whatever agency, whether, you know, these are subsidized projects with federal dollars, mainly. They're, for the most part, the way I understand it, they're uneconomic if they're not subsidized. So in that light, is it in the public interest when we have an insolvent federal government that's $31 trillion in debt to, you know, print more money or whatever to subsidize these projects? So I wanted to throw that out there as far as, is that in the public interest to enslave future generations with debt? Thank you, Madam Chair.
Senator Cole.
Thank you, Madam Chairman. Is there any court precedent to any of this eminent domain action that's been challenged in the state of Wyoming?
Madam Chairman, Senator Kolb, I believe that there is. I don't have the cases right in front of me, but I could definitely get that for you.
That would be great. Thank you very much. Just go ahead and put that on our list. Any further questions? All right. Oh, Senator French.
Thank you, Madam Co-Chair. How do they determine just compensation? Who determines that and how do they determine that?
Madam Chairman, Senator French, I am not entirely sure who determines what just compensation is. There might be somebody in the room who would be able to answer that question, though. Or otherwise, I mean, I could look it up as well.
Senator French, I think we do have people that may be able to answer that. If not, we'll put that on your list of things to look up for us and get back to the committee on. All right, any further discussion? All right, thank you. Senator Hicks.
I think probably one of the most pertinent things that this committee is going to have to understand as we get into this issue is the fact that there was proposed legislation in 2018, 2019, and 2023, and they all failed to extend the moratorium on collector systems. And until we understand the nature of why those failed, it seems like it might be a futile attempt to just bring back the same bill and try the same thing over and over again and expect a different result. So it would be important to understand the nature of those arguments and what the hurdle, how big the hurdle is that you have to get over. In other words, what was the vote? And so those are absolutely critical issues that this committee will have to understand if they want to move any potential legislation forward on this issue. And so it would be good to have us, if we continue to work on this issue, to have LSO come back and characterize the nature, or maybe some of the members, the nature of what those discussions were. And then I'd be curious to go back and understand what the vote was in relationship to the extension.
Thank you, Senator Hicks. I think Senator Chairman Case will be on the line and he ran several of those bills. You will remember most recently Representative Schlegel had a bill that passed and the governor vetoed that bill. So the legislature was on board. And what I remember, I think I will let Representative Schlegel tell us, give us some input onto what he heard about his bill or how we might fix it. But I think we're dealing with larger issues when Management Council assigned this topic to us. This is just one component of eminent domain that we were assigned to deal with. I think the most pressing at this time. However, we do know solar has become an issue in some parts of the state as well. So Representative Schlegel, do you have any comments on your bill from the last session?
Well, I think the main comment I would have is it did pass through both houses. Through the House was pretty close to being able to override when it passed out of the House originally. And then the governor, as Sherry said, did veto that bill. And I mean, I really think there's our biggest issue here is not the eminent domain. Well, it is the eminent domain, but it's the whole idea of private property rights. When our country was founded, our founding fathers considered private property rights on almost equal basis of life and liberty. And since that point in time, our Supreme Court has been taking that right away from us. It talks about it in the Constitution. And so I don't know how we overcome what the Supreme Court has done to us by some of the rulings that they've sent down over the last several generations. But that's where our issue is. Private property does not have the value in our eyes and society today as it did when our founding fathers set up our country. And I mean, I think that's going to be our big issue that Senator Hicks was talking about overcoming is we've got to people have got to understand that for our country to be vibrant and energetic in its economy, we've got to protect private property rights. Thank you.
Thank you, Representative Schlegel. All right, any further?
Yeah, Madam
discussion?
Chairman, could we get LSO to send out the governor's veto language on the bill? I'd like to read what his specific issue is, and at some point in time, we'll need to engage the executive branch on this issue as we move forward to understand if there's an expanded attempt, and we have actually strengthened our eminent domain laws and my tenure in the legislature, I believe in 2012. Was a lot of effort to get that done, and we need to look at that. And it was a battle, believe me, having sat through that. But I would concur that we're losing those freedoms. But I just want to know where we're headed with this. If it's just wind collectors, because the memo pretty much deals with transmission electricity. So are we going to take on our existing complete eminent domain laws and look at those, or are we going to be focused on utilities and electrical generation?
Co-Chairman Ekman.
Yeah, so anyway, two pretty good discussions on why we need eminent domain and also need private property rights and how they have to balance out. So I believe with the last discussions we had on eminent domain, it was a battle. And it went to conference committee, and if somebody can correct me, fine, but I think we stripped out some important provisions for landowners in a conference committee, which shouldn't have that much power, but they generally do. The committee will soon, if you don't know it already, you'll soon see that happens. So I think we need to maybe look at what those provisions were that were stripped out. And maybe we can set up some general rules that would prevent anybody from losing all of their private property rights in some of these cases. And I think eminent domain can make that happen. And I think those people won't necessarily be compensated for the government coming in and steamrolling their rights. So anyway, there has to be a balance of both. And I think that's why we're having the discussion.
So, Madam
Thank you,
Chairman,
Mr. Chairman.
not to belabor the discussion, but we need to segregate out whether we're talking about the government's use of eminent domain or the statutory component of private corporations and individuals and group of individuals using the right of eminent domain, because those are two completely separate issues. And what we're dealing with now, particularly with wind collectors, is not the government.
That's right.
We have the constitutional provision that deals with the governor's condemnation, and then we have statutory provision that allows further enhancement of the use of eminent domain by private individuals, corporations, and entities in the case of electrical transmission. And so I'm just trying to hone down, what are we going to focus our efforts on as the committee? Is it the government's use of eminent domain, or is it the statutory provisions that are covered? I believe that's in Title 126 that address some of these other issues. And so I'm trying to figure out how broad are we or how narrow are we going to try to address this issue?
Mr. Co-Chairman.
Chairman, I don't think I can make a distinction between the two, because what we're deciding here is basically policy by the government that will be established for private companies to operate under eminent domain. So I think they're probably about the same thing. If the state government were involved in it, we probably as a government should have to abide by the same rules that we impose on the private industry.
Mr. Chairman and Senator Hicks, I would like to propose that we listen to testimony today, and then maybe we can hone down what we decide to do as a committee on when we take up committee actions after we hear the issues that are facing our constituents and why this topic has come before us. And so that's what I'd like to do. Does that sound acceptable to you guys?
Absolutely.
All right. All right. With that, thank you, Anna. You have your list of other questions. I'm sure your list will get longer as the day goes by. And so we'll go to I think we have our Converse County Commissioners online today. So since Niobrara is in the room, maybe we'll let them go first. You are on our agenda under eminent domain. And so Commissioner Wade, would you like to come forward and lead off? And then we'll go to Commissioner Willix in Converse County online. Is he in the waiting room, Katie? He is. Oh, well, we will let him go second anyway, just because we've got him online, we've got him up. Sometimes our technology takes a little bit of time, so we'll start in the room and then we'll go to him next. Welcome, Commissioner Wade.
Good morning, Madam Chairman and Mr. Chairman. I appreciate this opportunity to visit with you all. Testifying today, not only as a county commissioner from a very strong property rights county for the people that I represent, but also as someone that helped organize and was a lead negotiator for what has now become 3 landowner groups. It was formed in eastern Wyoming to negotiate pipeline easements. And all three pipelines had the ability to condemn. And through my experiences with that, I've now helped been one of the lead negotiators on what has become in the hundreds of miles of pipeline easements for our members, maybe even rolling over 1,000 miles now. And representing landowners in North Dakota, Montana, Wyoming, Colorado, and Kansas. And through that experience, I've even been asked and have helped landowners in Colorado and Kansas negotiate. So I've had some experience, and the success of our groups, we can attribute to getting connected up with Frank Fallon as our attorney right off from Bud Fallon Law Offices in Cheyenne. And I gained a great education from them, but it was an education I was forced to take because of eminent domain laws. My education first began when I received a letter. My wife and I received a letter from a company notifying us, and this is quoting it right out of the letter, preparing to build a pipeline on or in the immediate vicinity of our property. It didn't say, we'd like to visit with you about the prospects of doing that. They said they were going to build that pipeline on or in the immediate vicinity of our property. Now, that's a pretty good way to pick a fight at our house. And we soon learned, of course, that they had eminent domain authority granted by the state. And right off, one of my mentors that was one of the other negotiators told me that when you're dealing with someone that has the ability to condemn, it's like dealing with someone that's got a gun held to your head. Now, that may be a little harsh, but you don't ever forget it's in their holster and it's there. So with that background, now I want to speak about wind and solar. While we're having this discussion, I think just well have both included. And that's what is probably the more pressing issue in my county right now. I've always heard some discussion on whether or not a company can condemn the actual footprint of the farm itself. And I'm not certain one way or the other. I'm not an attorney, but I think we'd all know how discussions would go with a private property owner if that was relayed to them by a wind or solar development company from the beginning. That's not a good way to start the discussions, as I explained a few minutes ago. But once that project leaves that landowner, things change, and that company then does have the ability to condemn. And that there's no question about that. Everyone involved in the project, from the top down, investors, consultants, contractors, attorneys, everyone up to that point has the ability to say no until you start down that power line. And then those people no longer can say no. And everyone involved in those projects will be there with prospect of profits, which I'm a capitalist, I understand that. But I don't believe it's right to put one person's rights at risk for another person's profit. And that's what this does. And it's especially bad to me because the people that benefit, especially financially, from this the most probably don't even live in our state, and maybe are foreign owned. So we're sacrificing what's going on in our state to benefit someone far away. Now, I had said I had taken quite an education on these easements, and this is where I'll start to explain some of the things here. The first thing that I learned, the first thing that any landowner should be concerned with an easement is liability, landowner liability. And the threat of condemnation makes this very difficult to negotiate. Now, this was a hard concept for me to get my head wrapped around. And Frank Fallon talked to me a lot about this, but it was hard for me to imagine how I should have any liability whatsoever when ultimately I could not keep the project from coming onto our property. And Frank's told me many times to not get not confuse the way things are and the way they should be. And that's a big thing. You know, if a landowner unknowingly damages those projects, he may have just sold the ranch. And so that's the kind of things that you live with. Our landowner groups were able eventually to limit landowner liability to intentional acts of harm. Now, that took a huge amount of time and effort by a lot of people and some top legal help. There were 2 or 3 of us that devoted close to a year on that first pipeline easement to accomplish what we did. Another problem with this is when someone negotiates for a wind or solar farm, they'll have the ability to negotiate the duration of the lease. So in other words, when the project's over, the easement goes away. Hopefully it's cleaned up, which is another concern of mine there, but everything goes away, it's cleaned up. Now, a company that has the ability to condemn a power line, I think is very likely to negotiate for a permanent easement so that that power line has another use. There are use after the fact. That's not fair to me. You know, that those landowners with those power lines, the project doesn't go away. Interestingly enough, kind of on a side note, this another thing I learned in this, the state on state lands negotiate term easements. They do not give a permanent easement. And I've never thought it's fair that the state operates under different rules for their lands than what we as private landowners are faced with. When you get one of those letters saying that a company's coming that has condemnation ability, you're put in a potential no-win situation. Especially for someone facing this for the first time as I was. You know nothing about it. While the person on the other side of the table, this is what they do every day. You're dealing with professionals. And that's what they do the full time. And it's, if you do go get good legal help, then you very quickly risk spending more money in legal help than you can ever hope to be paid for your easement. And we overcame that with our landowner groups because we pooled together our resources. And on our first pipeline group, we ended up representing about 3/4 of the pipeline miles that were in Wyoming. And we partnered with a similar organization in Montana. So we had enough people to spread that over to where we could make it cost effective. Otherwise, it's not. And there still are people that are not, they're just not comfortable having a group negotiate for them. So those people are really potentially at a great disadvantage. And you know, there may be some that worry that a landowner could hold a project hostage, and I don't believe that. There's ways to get around that, and all we're doing is trying to keep things, make everyone on a level playing field. So I hope this is helpful. As you can tell, this brings up a lot of memories to me and lessons that I was forced to learn because of the eminent domain laws. My wife, Joanne, puts this into perspective really well. When you get a letter from a company that has condemnation authority and they first contact you, you suddenly know that something that previously was not for sale to anyone at any price now suddenly is. And because of state statute, your biggest bargaining leverage has been taken away. With that, I'd stand for questions.
All right, thank you. Questions from the committee? Questions? All right, seeing none, thank you very much. That was very informational. And stick around, we might have questions later.
Thank you all.
And we'll go to Commissioner Willicks online now. And Pierre, I've lost my list of who all is online. I don't know where it is in my pile of papers, so. Oh, we've got one. Thank you. All right, Commissioner, whenever you're ready.
Thank you, Madam Chair, members of the committee. Jim Willicks, Commerce County Commissioner and current chairman of our board. You know, this topic raised its head a lot during session. There was a lot of discussion about the eminent domain. And in Commerce County, to my knowledge, and I know Anna's been collecting some stuff, the private entity has not used it around wind. But I believe Commissioner Wade is correct and others correct. Once it's there, it is a factor in any negotiations. There was also reference to government eminent domain. We are one of the counties that has used it basically, but pretty small. We've used it on roads that have already existed, but with current technology, we found out we didn't have an accurate survey. And so we actually used it in a couple of places for convenience. Everybody was on board. It was just a little easier to eminent domain a road where it actually already existed. It wasn't creating new space. It was just, we've learned with the oil and gas explorations out here that we had gaps in our roads. We had some roads that did this. We had some roads that did this. We had some roads that did this, and we got them connected to where they actually existed. But I want to commend Commissioner Wade. He dove into this before he was a commissioner, and I think he may have undersold how important those landowner groups were. Because of that major pipeline, they really set precedents about how groups can negotiate annual payments, things that can be really valuable to the landowner in exchange for the inconvenience of that pipeline, power line crossing their property. Like I said, it has not been used to my knowledge in Commerce County. Again, there's been lots of negotiations that it has hovered over. I think one of the other things that was concerning that came up during session was a project that was looking to lease a lot of state lands. And as I looked at your interim topic, it kind of combined state lands with eminent domain as the topic here. And there was a belief that there would be some isolated parcels leased up, and then a bunch of eminent domain would have to be used to bring those collector systems together. I will say on May 3rd, and I believe they've been the subject, Pronghorn H2 actually presented to the Commerce County Commissioners. I know Commissioner Wade and other Niobrara commissioners were able to tune in as well. And that's a huge wind project that is also then hydrogen. And what was presented to us in that meeting is the more traditional development idea, where they hope to find willing landowners. And then if there are state parcels connected to that, that would be how it'd be, would not be one here, one there, one somewhere else, and a collector's brought together. So that was what was presented to us, and I think alleviated some of the concerns that may have existed earlier surrounding this topic. So I would say that, and I believe they're on your agenda later today, Pronghorn, that they are more they meet the traditional wind that we've seen in our county. They have some receptive landowners, they have some non-receptive landowners that are looking for siting. And then I think the other thing that I would note in the wind permitting process in Converse County, we do require that they have their easements in place as part of the permit. And so they have used that. We've used that as a way to make sure that they can collect landowner engagement for both collector lines and for the actual wind farm. So I don't have a lot to add from my vantage point. Commissioner Wade is wearing two hats as a landowner, as a commissioner, but I would say that his points are well, that it is difficult to balance. And I think somebody said earlier, the public need or use for particularly energy development, and how do we get that energy from where it is in Wyoming to where others are going to use it as we export it, and protecting private property rights. And it's a delicate balance. And I know the legislature has made some efforts in that. And I don't think you will ever find a perfect eminent domain process, because somebody loses no matter what. And I don't envy those of you at the table, because that's the challenge, is either the development of a resource is going to be harmed or the private property rights are going to be harmed, and both have value. And it is difficult for sure to find that balance. So Madam Chair and members, I don't have a lot more to add. I would stand for any questions. I could be around for a little bit today. I appreciate you letting me participate remotely. My schedule just wouldn't let me get down to Torrington today, and I appreciate this opportunity.
Thank you, Commissioner. We appreciate you taking the time. Any questions for the Commissioner?
Madam Chairman.
Yes, Representative Eklund.
Yeah, Commissioner Willox, you mentioned use permits. Could you expound a little bit more on that, needing to have the use permits in place? Because I'm not sure I understand it. Maybe the committee does better, but tell us what you mean by that.
Madam Chair, Mr. Co-Chair, sorry, I kind of rushed over that. As part of the siting process, so if a wind or solar project falls under industrial siting, we also have a county permit under that, that's authorized under the statute. And one of the nuances of our county permit is to have those easements in place for those collector systems as part of issuing the permit. So that is what I was referring. Use permit was the wrong term, Mr. Chairman. And we currently have an applicant in front of us right now that is buttoning up, and we've got a hearing coming up in another week, 10 days. So that's part of it. And now that doesn't mean they can't use eminent domain. I'm not saying that that prevents the use of it, but it does. When we get to our level, we will have a sense of how they got to that point. Does that help, Mr. Chairman?
He's good. Thank you, Commissioner. Any further questions? Seeing none, thank you. Thank you for joining us today.
Thank you, Madam
Appreciate
Chair.
it. All right, next up on our agenda is the Office of State Lands and Investment.
Madam Chairman,
Yes, go ahead.
excuse me. We have both Kermit Brown and Ken Lay online for this topic also
Okay,
for public comment.
well, I was following our agenda that State Lands was next
Okay.
on the agenda. Should we go to them first? All right, well, let's go ahead and go to them so that we don't take too much of their time today, and we'll have State Lands come up next. Who would like to be first? Let's start with Mr. Lay, if he's available. Oh, Who have you got? Okay, that'll be fine. Welcome, Mr. Brown. Thank you for taking the time to be with us today. Welcome to the Ag Committee.
Thank you, Madam Chairman, and I see a lot of old friends and a lot of new friends there. It's a privilege to appear before you today, and I sort of miss what you're doing. I loved your rules discussion. These days, my rules discussions are on the first tee box, and usually the bet's won or lost right on the first tee box when the rules are being negotiated. So that's the importance of it. As
Okay.
you all know, I think you know, I'm a fierce private property rights advocate. I started the fight in 2012 and I guess I finished it, but we fell far short in 2012 of accomplishing what we hoped to accomplish. But the one thing that we were successful with that I think has helped landowners is at least they get that letter now. And before 2012, they didn't even get the letter. Now they get the letter with an appraisal and some notification of what is at hand. It used to be that they didn't hear anything. And I just want to diverge for a second, Madam Chairman. When they get that letter, Commissioner Wade complained about, well, the decision's already been made. Well, we learned, and you might just keep this in the back of your mind, we learned, especially on these big power line projects, the real negotiation on the route takes place before the FERC. That's the Federal Energy Regulatory Commission. And those fights and those discussions and those considerations are all decided at the FERC level. And by the time it gets to a landowner, there's no ability left to alter the direction of the line that's a power line that's going to be put in, because that decision was made at the FERC before the power line was ever permitted by them. So, and I see Mr. McGagna's in the room and he knows a lot about that. So I'll just leave that as it be. There's really 3 points that I want to make. Number one is my partner, Bill Heiser, who's from Converse County. I think the commissioners probably are familiar with him. His family owns a ranch in Converse County. And so I'm stealing a saying that he coined, but his saying is, the only thing worse than having a wind farm on your place is having a wind farm on your neighbor's place. The reasons for that are manifold, but here are a couple. The neighbor who's going to have the wind farm gets a choice. And I don't believe, I could be wrong. I don't believe there's a right to condemn for a wind farm itself. I could be wrong on that, but I don't think there is. In any event, these wind farms are all subject to negotiation, and the landowner on whose land the wind farm is going to go has a lot of say about whether it's going to be there, whether it's not, all sorts of things. He has all kinds of choices. The neighbor who's going to get the wind energy collector system lines has much less choice. His neighbor goes through the whole process and decides that he's going to do a wind farm and negotiates the price, and then the collector system has to come through his neighbor's land, and that's a matter of eminent domain. The landowner that has the wind farm is probably going to get periodic payments. The neighbor through whom the wind energy collector system is going to go is probably going to get a single payment, and that's it. And that's not fair in my mind. If the landowner that hosts the wind farm is going to get a periodic payment, why wouldn't the landowner who's going to host the wind collector system get the same sort of a periodic payment? So there's one issue that you might consider. And so I don't like eminent domain at all. I truly don't, but it just is manifestly unfair for one landowner to have all the choice, all the controls, and get periodic payments, and his neighbor, who's only going to get the collector system, has little or no choice, gets one lump sum payment. All that revenue is running through the wind collector system, but that landowner gets one lump sum payment, and that's it. Number two, these questions of valuation are typically almost always settled based on an appraisal. There's a fair market appraisal of the land, and the test typically applied by the courts is the value before minus the value after. And the difference is the fair market value. Now they negotiate up and down from there, and there are other things that go into it, but I never liked that. And when we started the fight in 2012, we tried to change that. My contention was it ought to be 3 times the money. And I could give on that. I mean, if if they're going to take your house, that's one thing. It's probably worth 3 times the money. If they're just going through a vacant field, then maybe it's only 2 times the money, but it ought to be more than appraised value, because just receiving appraised value for the property is not enough. Adjustments have to be made. Maybe you have to change your grazing rotation. Who knows? There are myriad things that go into it, and there are a lot of inconveniences involved with the imposition of that project. So just receiving the fair market value for the easement's not enough. And I tried for 3 times the money, and in 2012, let me tell you, there was blood on the floor. I remember I spent almost an entire day at the podium on the floor, and there was blood on the floor from one end to the other, and I just lost that one. The other thing about 3 times the money is, if a company comes in and offers a landowner 3 times the money, 3 times the appraisal, and the landowner still refuses, then it seems more equitable. Then the company can say, look, you're just being obstinate. You're just being unreasonable. And maybe they can go to a court with a much clearer conscience to exercise eminent domain. Where when it's just fair market value, there are too many other factors that enter into it. I just think the measure of compensation ought to be greater. The last thing I want to say is that Commissioner Wade's right about landowner liability, and that should be a consideration in any eminent domain that's going to take place with respect to collector lines, because and I could accept intentional acts, but short of that, I don't think that a landowner ought to have liability for damage to that system. And there are things that inadvertently happen that damage it, and landowners are potentially liable. And I don't think that's right, not when it's being forced down their throat. So those are the points that I have to make, Madam Chairman. I appreciate the opportunity to be before you today, and God bless you all for doing the people's work. I did it for 12 years, and I know how hard you're working. Thank you.
Thank you so much. Do we have any questions for Kermit? Seeing none. Thanks so much. We appreciate it. All right. Next, we have Mr. Lay online. Welcome, Mr. Lay.
Madam Chair, thank you very much for the opportunity. I want to thank Kermit for his extensive and I think very pertinent comments on all of this. When I have looked at this issue, it's very interesting to me that, the existing statutes are pretty clear. It's when you look at requirements for the exercise of eminent domain, what you find is that one of them is that a project is planned or located in a manner that will be most compatible with the greatest public good and the least private injury. And I think and then of course is that property that will be subject to eminent domain is necessary for the project. And I think when you put that together, you can begin to ask a lot of questions about how the system is implemented. And I think it's very important, because what you find, of course, is that developers who are interested in exercise, who may need to exercise eminent domain, they're actually interested in what is the least cost option for them, not what is going to produce the least private injury or the greatest public good. And I think that, that issue, we need to have a serious discussion about the way in which eminent domain is exercised in that connection. Typically, what will happen is these projects go off, as Kermit indicated, go off the FERC. they will go off to the Industrial Siting Council or to the Public Service Commission. And their whole process, which is actually for things like public convenience and necessity and so forth, is focused actually on the interests of, in the case of electric projects, you know, what's the ratepayer? What are the costs to ratepayers? Well, it's entirely conceivable that the damage to landowners who are subject to eminent domain may require an approach that is not necessarily the most cost-effective for ratepayers. And so you do have an issue that I think is we all need to think about that has not been adequately considered. There's also issues around the necessity of property for projects. And the interesting thing that I've found with that is there's a huge desire on the part of developers to avoid crossing, for example, federal land where there may be all kinds of procedural issues under NEPA or what have you that are required to do that. So what they try to do is then go across private land and say, oh, okay, well, if you're not interested in our crossing your property, why we may exercise eminent domain. At which point you say, well, wait a minute, I'm butting up against federal land or state land, and why don't you go that way? And I would make that point. There's also a question which comes up, which is that in the case of electric transmission, and again, wind is only one piece of this. There's also solar and other development. But on transmission, for example, it would be an interesting question to ask a utility, well, should you underground all of this power? Because that will be much, much less intrusive, much less encumbering on the value of property. Well, they'll say, oh, I'm sorry, but that's too expensive. And you say, okay, well, we have a trade-off here. You're trying to compel the use of private land under eminent domain when you could come back to us and say, well, okay, well, there is another way for us to get this power delivered. And my concern is that we are not having those kinds of conversations. I think we need to broaden this discussion. And I think the other issue that I keep coming back to, and I've spoken briefly with Chair Steinmetz about this too, is that we need much more transparency in this entire process. Because when a lot of the development that we're concerned about is occurring, the developers are routinely granted confidentiality rulings, and which prevents the public from actually getting a view in advance of what these proposals are, and can impede what I would describe as an open public dialogue about what is going to be the most appropriate balance that we could come to. And so sometimes property owners are going to find out in effect at the last minute that a project is being proposed that will result in, major infrastructure crossing their property, and of course, subject to eminent domain. So I really think that I think that we really need to take a look at this issue in a broader context with a focus on trying to ensure that that private sector parties who have access to eminent domain are in fact pursuing solutions that are going to have the least impact on private property owners, and that there is a much, much greater degree of transparency around all of this so that we can have an adequate public dialogue about it. And I'm assuming that our county commissioners would welcome that because of the role that they have in all of this, and that it would allow much, much more, I would say fully consensual assessment of the impacts of all of this development. Anyway, I'm going to stop there, but thank you very much for the opportunity.
Thank you so much for being with us, Mr. Lay, and for your comments. Are there any questions for Mr. Lay? Questions? All right, seeing none, we appreciate your input and we've taken some good notes. Thank you very much. All right, next, I think we have Chairman Case on the line, online. And Chairman Case, if you're there, we would love to hear from you. I do want to just make a note for everybody out there listening and watching. The screen is behind us, so we're not sure where to look. We can't make any eye contact with you as you're online. And so we are listening and taking copious notes, and we appreciate all of the people that have taken time out of their day today to join us on this topic. So Senator Case.
Thank you very much, Madam Chairwoman. I will be very brief. I'm in a very noisy environment in an airport. I'm grateful for this opportunity to address the committee. I've wanted to perhaps to point us all in the direction of being a little bit more generic is how we approach this and separate in our minds public utility facilities, which have a certificate from the Public Service Commission, from other facilities, because we are just beginning to see all sorts of different electrical pieces in this puzzle. There will be independent battery storage facilities, there will be pumped hydro, there will be nuclear plants, there will be solar, and of course there will be wind. And I think we need a policy that's kind of fair to everybody. I concur with former Speaker Brown's comments about Wyoming. It seems like so far with the renewable energy boom, there have definitely been some great winners. Certainly our landowners have done well, who've had facilities on their property for generation. And these are by and large very arm's length negotiations for the best wind spots, the best solar spots, and they've been generous to landowners. That's why you'll see those landowners with facilities on their property being very adamant that Wyoming shouldn't discourage its industry. But it comes at a cost, and it comes at a cost to their neighbors. And really, in the very big picture of things, we have to ask the questions about, is Wyoming getting enough for the renewables in our future? And one way, I think, is to at least take care of our landowners who get imposed with all these associated facilities with power generation, independent power generation, and make sure that they have a chance to get a fair deal too. So I concur with the comments of Mr. Lay and the comments of former Speaker Brown. I remember very well the efforts when Speaker Brown was in office, and we shared a lot of things. It's a very noisy environment here, so I'll take any questions if you wish, but I thank you for addressing this topic. I did send a proposed generic language that's not tied to wind and only is if you are a public utility or not, in essence. And so if you're not, I'm sorry, Madam Chairwoman.
No, I was just going to thank you for that. We did receive that, and LSO received that, but I did not mean to interrupt you. So go ahead.
I'm just wrapping up, Madam Chairwoman. That document is a bill that would allow for public eminent domain to be exercised by projects that have a certificate of public convenience and necessity from the Public Service Commission. And I think that's a good appropriate way to address this. It's generic. I rewrote that to be generic with respect to the type of generation, not necessarily wind, but all sorts of different power generation that would be independent. Thank you so much, Madam Chairwoman, for making this time available.
Thank you, Mr. Chairman. Does anyone have a question? Senator Hicks has a question for you.
Yeah, Senator Case, thank you for providing that. The question I have is when it comes to the certificate of public benefit that the PSC produces, do they do those per PURPA qualifying facilities or are they outside of that certificate from PSC? Is that what we're getting at for these PURPA qualifying facilities?
Madam Chairwoman, in essence, that's correct. A public utility can contract for services from a third party and get and obtain protection of the certificate. But for merchant plants that are built to impose the PURPA requirements, which are the avoided cost requirements, then they would be not available for eminent domain.
Thank you.
Any further questions? Seeing none. Thank you, Senator Case, for taking time out of your busy day to join us and provide that information to us.
Well, it's been crazy, Madam Chairwoman. I started out flying from Denver to DC, and I'm now in San Francisco, and it's quite an explanation.
Oh, goodness. Well, we hope you get there safely. And thank you for bringing up Speaker Brown. He was my first speaker when I came into the legislature, so we appreciate his knowledge today as well. Have a good trip.
Thank you, guys.
All right. Katie, do we have anyone else online? I know we had Mr. Sweeney was signed up. Is he online for public comment? All right. Any further online at all? Seeing none, we will now go to the Office of State Lands, and thank you for your patience as we dealt with everyone's time schedules today. And we were hoping to get an update on the Pronghorn project. And then after that, we will do public comment and go into your regular update after that. But if we could hear a little bit more about the Pronghorn project, which spurred much of the legislation that came forward this session. Welcome, Mr. Crowder, and we appreciate you being here today.
Thank you, Madam Chairman. My name is Jason Crowder. I'm the Deputy Director for the Office of State Lands and Investments. And thanks for clarifying our topic, because I don't know that we'd have a lot to add for the eminent domain discussion. We don't play in that arena very often, if ever. But for an update for the Pronghorn H2 Wind Energy Development Project, the office did receive an application from Pronghorn H2 LLC on July 21st, 2022. It covered 2 counties, Converse and Niobrara County, identified 117,037 acres of state trust land, which is a very large project. We understood the whole project may reach up to 300,000 acres. We also understood that roughly only 40% of that total would be state land and the rest would be private land included in the project. At this time, we only understand this to be a lease application for wind energy development. Everything else that's been discussed as far as hydrogen hubs or anything further like that is not contemplated in this lease. And the office hasn't done anything to that end. We're simply just looking at wind energy development right now. It's also important to know that this application, although it was submitted last summer, is still in its very early stages of analysis and of development as far as a lease goes. It's a very large project, and you can understand that when the projects get larger and larger, they take more and more time to get all of the boxes checked in order for us to have something we can provide to the Board of Land Commissioners for consideration. So it's still in those beginning stages. Right now, it is in the lessee consent and parcel identification stage, meaning that part of the Board of Land Commissioners rules, Chapter 6 of its rules, require that any proponent coming to provide an application to the board needs to get consent and comment from all of the surface lessees that are impacted by that project. We've given those forms to Pronghorn H2. They've obviously sent those forms out to the lessees of the parcels that they're looking at, and we're in the process of getting those back. In fact, I don't know that we've gotten more than maybe 2 or 3 back. So we've got a lot of road to go there, but it is a requirement that Pronghorn do that before we can provide anything to the board for consideration.
Right there, if you wouldn't mind. So what happens if you don't receive those back? Is that a requirement for them to proceed forward? How does that work?
Great question, Madam Chairman. It is a requirement for it to move forward. However, if there just isn't any communication between the applicant and the surface lessee, the board's rules do allow for the office to come in and do an analysis of the substantial impacts the project may have to that existing lessee. It gives us 20 days prior to final board consideration to complete that analysis. We send a notification to that surface lessee telling them that we are going to undergo that process and kick off the 20-day process and have a determination made by the office for a recommendation to the board. The board is the ultimate entity that will decide if there's substantial impacts or not. But do understand that is the very last thing that occurs. Before we get into that process, we work very hard with the applicant to ensure that they've done everything they can to not only contact the surface lessee, but to try to discuss and mitigate any impacts that may be there. So that process I just laid out is the last resort before moving a project forward for consideration.
And then a follow-up to that, and I know we've discussed this before, and maybe you've run it to ground a little bit. Why is it placed upon the lessee to decide the impact and to do that analysis rather than the company not having to provide facts that they won't be impacting the lessee's lease, basically?
Another good question, Madam Chair, and really we need both perspectives. It is incumbent on the lessee to give us that information because they know it better than we would. So you need a couple parties to, in that negotiation or in that discussion to come up with the best outcome. The Office of State Lands will likely not be that person or that entity. It needs to be whoever is on the ground, whoever is directly impacted, their operations or how they use state land. So the process has been built that they have a very large seat at the table, a very large voice when it comes to those discussions and negotiations for those reasons. And those are very important reasons. But we also require the applicants to give us just as much information that their project will either not negatively impact a surface lessee operation in a substantial way, or they've come up with ways to mitigate those impacts. And Madam Chair, going along the lines of the consent forms, we discussed this during the session, but there was some communication specific to the Pronghorn H2 project and the consultants that they used on how they were discussing how they were coming onto the property and the need for the consent forms to be filled out and who may be sponsoring the program. And some of those communications alluded to the fact that the state might be sponsoring that program. We obviously reached out to Pronghorn immediately and said that we're not. We're giving you the opportunity based on the land ownership that we manage to do a wind project on us because that's something that the board has allowed and has written rules around. But we're not sponsoring your project. We're simply allowing that opportunity because of where our land sits. They also pulled back their consultants, and I provided the committee with all of the correspondence, the updated correspondence and replacement correspondence to make sure that the lessees knew that the state was not sponsoring it, that this was a private entity moving forward, and that all negotiations going forward would be done in good faith and again, to ask any questions that they had of the applicant. So I hope that met what the committee was looking for during the interim or during the session. And if there's more, we'd be happy to help in that way.
Thank you very much. Are there any questions? Go ahead, Representative Craigo.
Thank you, Madam Chairman, Deputy Director. I just had a few questions going back to some of your comments regarding the consent. So does just so we're all on the same page, does the surface lessee, whether it be ag, mineral, whatever, do they have veto power over any and all projects that apply for a subsequent lease?
Madam Chair, Representative Craigo, they don't have veto power. Again, we have the 20-day process that allows the office and the board to analyze the substantial impacts if there are any, but it's the board, the owner of the land that the project will be on that has the ultimate authority.
Follow up, Madam Chairman.
Yep.
So really the consent isn't a requirement. It's a requirement that they ask, but it's not a requirement that they actually receive the consent, correct?
Madam Chair, perhaps I misunderstood the earlier question. Consent is required for us to move forward in the process. If they cannot receive consent, then we have the 20-day process that we can fall back on. But we won't take action to put it in front of the board until consent is required or the 20-day process has been completed.
So just
Follow up.
follow
Go
up.
ahead.
So just to be clear, because I want to make sure we're all on the same page here. Consent is not required. If they don't receive the consent, then state lands can go through the 20-day process and sidestep the consent of the current lessee, surface lessee, correct?
Madam Chair and Representative Craig, you're correct in the way you stated it. What I want to be clear about is that we don't allow a non-consenting situation to move forward in our administrative process until there's just no way for it to not move forward other than that.
All right, you good? Or one more? Go ahead.
So that's last resort, but it's always an option for state lands.
Madam Chair, that's correct.
Thank you.
All right, thank you. Well, thank you, Jason. We'll see. Go ahead. Yes, go ahead, Senator Hicks.
So Jason, specific to the Pronghorn project, do you know if the applicant is a utility or is a subsidiary of a public utility? Or is this a completely independent entity? This gets back to Senator Case's suggestion of dealing with, we're going to see it peripherally, but do we know whether they are a public utility or a subsidiary?
Madam Chair and Senator Hicks, I do have a few more bullet points to get through, and I think I'll get to that.
Okay.
Right now, we don't. Right now, we understand that all wind developed off of the project would go to feed the hydrogen hub project in the future. There hasn't been an indication to us that they're going to get on a grid somehow or provide their own grid in any way. So right now, we don't know that. And I will say that that's kind of a unique situation because typically all wind development on state lands anyway goes to power a grid of some form or fashion, and it goes to wherever it goes and is sold however it's sold. So we would need to do a different analysis as far as the revenue stream and understanding how that might impact our lease terms going forward. But we're not even close to that yet.
Well, and the reason I ask that, because it gets into this whole certificate of public benefit that would come through PSC. And even if they're going to be a substantially large generator, they're skirting the process because they're not a public utility. And so that's something I think is that we're going to see more and more of. And I think Senator Case highlighted that, and it may be for these independent projects. And it's something that we have to get our arms around, because right now they're not required to go through PSC to do these. And so they're not a regulated producer. They're a producer, not a utility. And that's a very important distinguishment in how we move forward with how we want to address these in regards to eminent domain.
Any further questions before we continue on? All right, go ahead.
Quickly, Madam Chair, the only thing that I think I have left here is that the timeline that Pronghorn has given us as far as lease execution is nowhere in the near future. They've targeted construction for 2026, but we've not begun the lease negotiation process, which does take some time. We've provided Pronghorn with a template lease, but we haven't seen anything back. So the ball is in their court as far as giving us terms to negotiate through. So to recap, what's been done is that consent forms have been sent to the surface lessees. OSLI has sent a draft lease to Pronghorn, and OSLI has verified that all the lands in the initial application are actually owned by the state. But what needs to happen next is that OSLI needs to analyze each parcel to see if it's in a sage grouse core area, to identify any other environmental or habitat concerns that need to be mitigated, and to identify all of the existing uses on that property. Because as you know, our wind leases have some consideration to existing uses versus future uses, especially when it comes to oil and gas, and how the two will play together in the sandbox, if you will. What needs to happen next is that finalize all of those negotiations. And what we're expecting is that Pronghorn will continue to have conversations as far as habitat impacts with the Wyoming Game and Fish Department and the U.S. Fish and Wildlife Service. They will likely be talking with DEQ, although we don't know exactly to the extent that'll be. And any bonding with a project this size will likely be held by DEQ and not with the office. We will require that a majority of the private leases be negotiated and secured before the board begins its final negotiations. And that any lease that we do end up providing to the board for consideration will include a favored nations clause, and that'll ensure that the state receives as favorable of terms and market considerations as any other private negotiations. We also expect that Pronghorn will come to us and formally ask to split this project up, split Converse from Niobrara County, and then we may have 2 leases and possibly more as they go through the landowner negotiation and the project development phases. But again, Madam Chair, happy to answer any other questions.
All right, I'd go ahead, Representative Craigle.
Thank you, Madam Chairman. So just a couple questions. One, do you have any idea why Pronghorn is wanting to put all of the project on state land versus private property? That, I mean, obviously there's lots of private in that part of the world as well, different than other parts of Wyoming. Do you know why they're wanting to do it all on state lands?
Madam Chair, Representative Craigo, we don't understand that, actually. We understand state lands to only be 40% of the project, and that 60% would be private lands in the project. So we would anticipate the infrastructure also to be on private lands and not just on state lands.
Go ahead.
Follow up, Madam Chairman. And then do we have any idea what the annual revenue will be to the state of Wyoming based on the entire project?
Madam Chair, Representative Craigo, we don't yet. That's part of the lease term negotiations, is to negotiate the compensation package.
Do we have parameters on that? I mean, what are we looking at as far as comparison to market rate, i.e. on surrounding private deeded property? What is our negotiation parameter as far as that goes?
Go ahead.
Madam Chair, that's a great question. We do have some leases that have already been negotiated, and we use those as kind of our standard or starting template to work from. Each project is very different. And as we've already discussed, this project not being tied to a grid possibly would be something that maybe our existing compensation structure doesn't fully house, and we would need to address that in more terms or different terms. I don't have all of the numbers for all the other leases that we've negotiated, but we do have minimum per acre rentals. We do have a minimum fee on the amount of megawatt capacity each wind turbine can generate when it's installed. We do have what we call quasi royalty payment based off of all the megawatts that are produced off of state land and moved onto a grid or moved off of state land anyway. But there's a lot of different parameters and a lot of different thresholds that each compensation piece triggers throughout the lease.
Go
Madam Chairman.
ahead, go ahead.
Is there any way we could look at some of those leases? Would you mind just giving us a couple, maybe emailing the committees?
Absolutely.
A couple samples just to see what they look like and what, maybe high, low. And so I just am interested in what the terms are that the state requires. Thank you.
All right, Representative Davis is next. Go ahead.
Yes, Madam Chair. Could you, do we do with the state lands an EA or an analysis like that with any of this permits or unlike the federal ground we do and stuff like that? That's my question. Is that a requirement as part of the permitting?
Madam Chair, Representative Davis, we don't. We're not subject to the NEPA acts. So we don't do any environmental consideration in the office. But with projects like this, they are working with DEQ. They are working with the Wyoming Game and Fish Department, and then obviously the Fish and Wildlife Service in these cases. So some environmental analysis has been done. We also try to work with the Game and Fish Department and with SHPO to understand if there are anything out there that we need to be sensitive to or place lease stipulations around. But as far as the NEPA process, we don't do that analysis.
Madam Chair. Follow up.
Go ahead.
My only reason was you pointed out that we were in the grouse core area. So that was why I was wondering if we're fall outside of some of those regulations and things.
Madam Chair,
All right,
Representative
thank you.
Davis, that's a good question. We need to do that analysis to see if any of these parcels are within the core area. And we're doing that subject to the governor's executive order. And part of that executive order and how the board has determined when leasing will occur is that it won't occur within sage grouse core area. So if a parcel or a partial of a parcel is within a core area, we'll cut that out of the lease.
All right, Senator Kolb and then Senator Ide.
Thank you, Madam Chairman. Good morning. Question I have is is there something that would stop you from considering these projects as utility project hooking to a grid? Because it seems like there might be you tell me, is there some advantage by not having them hooking to the grid and supplying power like a utility would? So why couldn't we just consider them all in that light? Because I'd really like to hear what you have to say about that. Thank you. Madam Chair.
Go ahead.
And Madam Chair and Senator Kolb, I think you're talking about dynamics of a project that we don't contemplate when issuing a lease. We're issuing a lease for an individual who's going to generate wind energy or energy from wind development. They're going to provide a revenue stream to the beneficiaries based on that. We have put structures in place within the lease on how that revenue stream will look based on where they sell it. If it's a utility or otherwise. But outside of that, we don't, I guess, pay much attention to how they're regulated outside.
Follow up.
Go ahead.
Thank you, Madam Chair. But could you put it in there and treat them as a utility? That's the question.
Madam Chair, I think we could analyze that and understand what the implications would be. Right now, I don't think I can give you a good answer on could we or would we. What we need to understand is what is the financial benefit, the compensation back to the beneficiaries by doing that.
All right, you good? All right, Senator Ide.
Thank you, Madam Chair, Deputy Crowder. You talked early on about how the wind is sort of the precursor to the hydrogen hub. And there hasn't been much discussion on, I've heard landowner concerns about water aquifer situations out there. Do you guys weigh in on that issue before you start, looking at everything else? Thank you.
Madam
Go
Chair, Senator Ide, a good question, and we don't. We rely on the state engineer's office to do that work and to make sure that whatever is needed to be done to get into that aquifer, that they do that. We do have provisions within the lease that if there are regulations by other state agencies that they have to abide by those.
Senator Kolb.
Thank you, Madam Chair. Jason, it seems, I don't know, insane to me that these folks won't hook up to utility power. Okay. They will. They have to. I just don't know how you can operate a plant in this facility without having a reliable source of power. Now, with that, they're going to be connected. Do you take any of that into consideration? Are they saying this is a standalone project? It sits out in the middle of wherever it is in Wyoming, and it doesn't do anything but take in power from the wind generation system. Could you give me what's your answer, I guess? Thank you.
Madam Chair, Senator Kolb, only thing I can tell you right now is what they've referenced to us is that the power will be solely used by the hydrogen hub. What I can also tell you is that we're in the very early stages of this application. And as we go forward, if there is an opportunity for them to attach to the grid, then we'll have that captured within the lease as far as how the revenue stream will be structured. And if they do sell it in that manner, we can get paid appropriately that way. But being this early in the application, we just simply don't know the answer to that.
All right, any further questions? Just one in closing, we're asking you a lot of questions. We probably need to ask the company themselves. So thank you for helping us with that. But in the end, the SLIB would have to approve this, right? Our top 5 elected officials. And so it couldn't just happen without their approval. Is that correct?
Madam Chair, you're correct. It's the State Board of Land Commissioners, and they will consider the lease in an open public meeting. And if anybody wants to provide public comment at that time, they sure can.
Yeah, I mean, that's a long ways down the road, but just as a safeguard to put some of our minds at ease.
Absolutely, Madam Chair.
All right. Thank you very much. We'll see you back in a little while after public comment. And so we will open up public comment within the room. Whoever would like to be next and address this issue, come on down. Welcome, Mr. Ellis. Thanks for being with us today.
Morning, Madam Chair, committee. My name is John Ellis, and my comments today, I'm sure, is going to be somewhat different than what you've been hearing. I've been in the ranching business for 56 years in Wyoming, 36 years in Carbon County, and 20 years in Goshen County coming this November. My wife and I started in Carbon County when I was 23 years old upon the death of my father. In that many years, I would hope that we have learned some things. We've seen lots of changes and huge changes in Wyoming, and a lot of changes that has been brought on by, not by the people in Wyoming, but by outside influences. And I think we're at the point now where I was really pleased with when they passed HB 106, because gave me hope that some of the craziness was going to stop in Wyoming, and that Wyoming was going to take hold and mark our own destiny. I strongly believe that when you start drafting a new bill on eminent domain, that it should completely stop wind and solar from being able to condemn a right of way. That's a little bit harsh, but I really believe that. These companies that have wind and solar farms are private companies and hope to sell to large public entities. When you pass a bill that gives them the right of condemnation, then you're opening the door to any private person to condemn if he can prove it's for the greater good. I would like to address what wind and solar does and has already done in Carbon County, and what could happen in Goshen County if we're not happy. First, in Carbon County, they have completely ruined, in my estimation, completely ruined the environment around these wind farms. And that is affecting the land value, as you know. There are lots of big corporate-owned ranches in Carbon County that were there long before green energy. If a wind farm is developed, people will not look at the land next to the development is completing the property value, wildlife, and the viewscape and the tranquility for which our state is known. Is that for the greater good? This type of energy ruins all that. In Carbon County, the wind farms around Medicine Bow, Rock River, Shirley Basin, Hanna produce around $6 million of property tax for Carbon County. And so far don't produce any production tax because of the government exemption, because there's 3 years before they can produce any other revenue to the county. These wind farms have around 7 permanent employees. 1 lives in Casper, 2 lives in Saratoga, the rest lives in Laramie and Denver. All these companies promise people living in the little outlying towns. There's 2 ranches in the Saratoga Valley, Big Creek Ranch and Three Forks Ranch, both big dude ranches. Big Creek Ranch produces over $10 million in property tax and employs 150 people in the winter and 300 people in the summer. Three Forks Ranch pays $6 million in property tax and employs 30 plus people year round. They also pay lodging tax plus what their employees contribute to the community. That goes to show you what a farce green energy is, especially when wind is only 15% efficient and is subsidized 80% by the federal government, your tax dollars. And to what Pat Wade said a while ago, when you hire an attorney to fight against these people, you're actually fighting against your own money, because the federal government subsidizes them to the point of where you're using your money and they're using your money against you. So, and then for the sake of people who's going to argue that coal is a bad thing, I've ridden horseback over the coal mines in the Hannah Basin and seen deer, antelope, elk flourishing as well as lots of cattle. These lands are actually better than they were before the mines because they made water ponds where there weren't any before the land was reclaimed. We don't even know if wind can be reclaimed back to normal, and solar kills the environment under them. We don't know how long it will take to come back. We do know that when the federal subsidies end, for wind and solar, these companies are not sustainable. Then you are left with the cleanup. I could add more there, but I'm not going to. Now, to Goshen County. We're different in Goshen County and even more vulnerable. We're the #1 agricultural producing county in the state. We do not have much public land and are much closer to our neighbors than the folks in Carbon County. So therefore, a wind farm or solar farm has much more impact than in Carbon County. In other words, if you put a wind farm or a solar farm 300 feet from your neighbor's home, or you're naturally affecting the value of his farm. Then if they have the right to condemn a power line, they deplete this value even more. When you affect agriculture to that extent, that then affects the economy of the whole county. Also remember that these green energy companies are self-recorded, so you don't know if their production figures that they give you are true or not. And I don't know how you find out whether they do or not. And that brings me out of my speech here, but when you put these, when you look at the, I have to think here a second, but when you look at what they're doing to the state of Wyoming, to the scenery, the value, what Wyoming has been for, in my time, a lot of years, we're ruining the state of Wyoming with these things, absolutely ruining. Tourism was the #2 industry in the state of Wyoming. How many people wants to come to Wyoming and see wind farms and solar farms all over the state of Wyoming? They don't. Let's examine who's pushing much of this in Wyoming. Bill Gates and Warren Buffett are making millions of dollars off the taxpayers. They could care less what happens to the great state of Wyoming. And I have a little statement in there about the governor, but I'm not going to read it. I watched the Senate congressional hearings on electric grid resilience and reliability, which John Barrasso is the ranking member. They said that we are in a crisis, and John Barrasso, I don't know if any of you seen that or not, but John Barrasso had a picture of the United States, and there's only one little place in the United States that was in the gray. The rest was in either orange or bright red, which is definitely going to have blackouts. But that is around Missouri. The reason that Missouri is safe is because they didn't go along with the taking away the coal-fired power plants. They kept them going. They said that we're in a crisis mode because we have moved much too fast in getting rid of coal-fired energy to keep coal-fired energy plants, that we don't have the technology yet to keep up. It will be at least 2040, they said, before we have that technology. They also said that if we're spending the money on perfecting the emissions on fossil fuel that we are spending on green energy, we would be way ahead and safe from massive blackouts. With that, I want to thank you, Madam Chair, and the committee. And I would like to ask, I will ask, I know it won't go anywhere, but I'm going to ask that you put a moratorium on wind and solar in the state of Wyoming until 2030. Thank you.
Thank you, Mr. Ellis. Any questions? Any questions, Senator Cole?
Thank you, Madam Chair. Yeah, I'd first would say if you really want to see some updated wind rules, which is what you need, go to Sweetwater County, look at the planning and zoning folks. You can't, the moratoriums, I'm unaware that's even possible because it's illegal. So it's basically can't do that, but you can put regulations in. So I do appreciate your comments, though. I think you're trying to articulate what a lot of folks are.
Exactly. And I said that because I know it's probably impossible, but we're to the point in Wyoming where we definitely need to set our own destiny and quit letting the federal government rule us and tell us what to do. Wyoming could be one of the most, we were the richest county or state in this union for a long time. And the federal government has taken that away from us and we let it happen. So with that, thank you.
Thank you. Senator Hicks.
Mr. Chairman, John, in your previous life of a commissioner and in dealing with the Commissioners Association, are you aware of any of the commissions around the state that denied a conditional use permit for the permitting of any of these solar or wind facilities?
Yes, I think our good chairman of the county, of the Carbon County Commission, I think they just denied a permit, use permit here just on this one of these last deals that they had. I don't know exactly where it is over there, whether it's around Medicine Bow or where it was, but yes, I know they've denied one of the permits. I don't know what's come of it yet. I haven't talked to them to see.
Well, Madam Chairman, the only reason I bring that up is it's not only the legislature has a few tools in their quiver, but you can't always look at us for the solution when some of those solutions may be available at the local level. And yet, if this is a real issue, is why aren't the commissions actually denying these conditional use permits for these industrial facilities? And I don't know the answer to that, but I'm posing the question is I'm sure that it's got a provision to be challenged in court on that, but we need a partner there also, is what I would say.
Yes.
Senator Cole.
Thank you, Madam Chair. Yeah, quickly, Sweetwater County denied a permit. I was there as a commissioner when it happened. What I will tell you is conditional use permit is a local solution to this problem. You get the county commissioners involved who are elected,
yes,
and get them involved with this. And the solution is always closest to the people or those elected people, right?
yeah.
Those are the ones you should be talking to. Anyway, you need to adopt. I could just tell you there's a way of doing it, and I mentioned it earlier. I would look into that and find out just what you can do.
Yes, and I think that the county commissioners definitely need to look at their land use plan and update those to compensate for this. And thank goodness in Goshen County, we have the knowledge of Carbon County's commission where they've learned from the bottom up to fight this thing and learn the good parts and the bad parts of wind power, and these big companies that they're dealing with, learn the pitfalls that you learn when you start messing with them, that, they definitely we need to make land use plans that are much stricter than what we have.
Madam Chairman, just to follow up there again, as your previous time as a commissioner, and I know we've got some other commissioners here at some point, public comment if they'd like to weigh in on it, but Wyoming's pretty steeped in the philosophy of local control. And so one of the things that if we needed to, the legislature could look at actually beefing up those provision of those conditional use permits to have veto authority over those. Obviously, there's always a higher authority.
Yes.
But that's something that, again, we need a partner there if we're really going to implement local control. And I'll throw that out to the county commissioners as if that's something that they would like to explore as this committee continues to move forward with eminent domain associated with these wind and solar facilities. Do the county want more authority over the permitting of those or not?
Oh, if I was still county commissioner, I would be 100% in favor of having more control, much more control. Because I'm a firm believer in local control. I think that our government should start from the bottom up because they're the closest to the people and definitely need local control and definitely need our commissioners to be involved with that and our see, that's why I told you I'm not county commissioner anymore.
I suffer from the same.
Any other questions for past commissioner and chairman of our commissioner, John Ellis? All right, seeing none, thank you, John.
Thank you,
Appreciate it.
Madam Chair.
All right, further public comment. Come on down. And two at a time can come down. There's two microphones and then we can let one go and kind of, since it takes a while to get down here, we can be getting ready for the next speaker. So just a reminder, please state your name, where you're from, if you're representing anybody or just yourself, and go right ahead.
Yeah, I'm Jim Fruity. His name's James Fruity. I'm representing myself, and don't be too impressed by my attaché case that says annual meeting of Wyoming State Bar. I inherited that from my baby brother, Paul. In 74 years, there's three things I'm pretty sure of. I never want to be a lawyer. I never want to be in the legislature, and I never want to be a county commissioner. But the reason I'm here is because what I've got here is a summons. I have a personal interest in this condemnation because there's two couples listed on here, my wife and myself, and it's summons and condemnation for a pipeline project. It was the Etsy pipeline. They were going to take coal slurry from Campbell County down to New Orleans. And what they did is they came in. I had the original agreement that people were forced to sign. We had a meeting in Lusk with their lawyer present, and all the landowners were there. And their lawyer says, if you don't sign this, I'm going to file condemnation against all of you next week. Everybody capitulated except two couples. Well, there was one rancher in Weston County that didn't capitulate also. I went up to his trial in Newcastle. I sat through that and I took copious notes. And my brother was there who was a lawyer. And we said, no, we can't afford to hire a lawyer because with Pat Wade and that deal, they all went together. Everybody else laid down. We can't afford to hire a lawyer. I said, I'll be my own lawyer. We'll go to court. And so I sat through that trial, a jury trial for that guy. The jury gave him multiple times what the appraised value, what was being offered him. The jury gave him that. Okay, so I go home and I'm ready for my court case, right? It's wintertime. I got time. I got time to prepare. Do you think they took me to court then? No, they waited till I was in calving season. And then they said, okay, now show up. There's no way I can do it. I'm going to lose way too much money doing this. And so I finally settled for a minuscule amount. The reason I didn't sign this was they were putting that pipeline right in front of my house. My house is built on a hill over a creek. I've got a vista for many miles out there, and that scar was going to be there for the rest of my life. You cannot cover that up. And I said, okay, I'll sign it if you put it behind my house. And they said, no, that's going to be a little longer, so we won't do that. Well, what about the guy that went to court and the jury gave him the money? They appealed it. They got way more money for lawyers. They've got all these guys on retainer. They got more lawyers than anybody. They overturned it on appeal, and there was nothing he could do. He eventually took bankruptcy. And so that's why this condemnation is pretty personal to me. I just spent more money to have that lifted, that easement lifted just this year than I got from the original easement. This is a really sore subject for me, this condemnation deal, because the companies just abuse the landowner. And in this case, they abused all the landowners with the threat of condemnation, sign it, or we're going to file condemnation next week. And so if there's any questions, I'd be happy to try to answer them.
Thank you, Mr. Cruzy. Are there any questions? Questions for Mr. Cruzy? All right, thank you for making the trip down today.
Thank you.
Next up. Go ahead.
Good morning, Madam Chair, Mr.
morning.
Chairman. My name is Isaac Sutphin. I am a partner at the law firm of Holland and Hart. Mr. Cruzy's bag was from the State Bar Convention in 2003. I have that bag. That was the very first year that I was licensed to practice law in Wyoming. And I'm obviously in the minority here because I did want to be a lawyer. And I appreciate, Madam Chair, your opening quote about finding answers together. And I'm grateful to be able to come before you today. As I mentioned, I'm a partner at Holland and Hart. I've done a lot of work for companies in the industry sector. I have 15 plus years of experience in eminent domain. And I hope that I can share a little bit of that experience and help again find answers together. I have also had over the years opportunity to represent some landowners. I've seen both sides of the eminent domain equation, if you will. I will try to be brief, and I will try to kind of outline just an overview of what I hope I can share and how it might help guide your future discussions. First, the members of the committee from the House side will recognize this catchphrase, but eminent domain is fair and balanced. You've heard a lot today, and you will undoubtedly hear more about how eminent domain is a bludgeon, is a tool that aggressive companies use to force agreement, and I will share with you some examples of how that is actually not the case, and instead that the Eminent Domain Act is the result of many, many years of legislation, of amendments, of efforts by your predecessors and also by the courts to sort out this very complicated balancing act between owners, landowners, and private property rights on the one hand, and the development of our state's resources on the other. I'll share with you some examples of how the Eminent Domain Act in its current form and how it is applied in the courts actually result in significant compensation to the landowners. We heard reference from former Speaker Brown about 3 times the appraised value of the property. I will give you some very specific examples that the payments that are being made now are far, far more than 3 times the appraised value. And then finally, I'll end with a quick overview of how many industries are choosing to invest their capital in other states as a result of some of the challenges, and that ultimately my recommendation to you is that you not tamper any further with the Eminent Domain Act, again, because I believe it's been well balanced and well established. I'll also attempt to answer some of the questions that you've already raised. I'm a lawyer and I love my job and I like to geek out about eminent domain, believe it or not. But I also don't typically toot my own horn. But I have been doing this a long time and I feel like I have something I can offer. You heard reference already to some of the requirements of eminent domain. This act has been in place for many, many years. The right to eminent domain is constitutional, as you've already heard. The requirements to exercise the power of eminent domain are explicitly spelled out in statute and must be complied with precision if a court is going to, number one, allow the take, and number two, grant compensation and make a decision about that. So those requirements, public interest and necessity, for example, that the property sought is necessary for the project. These types of requirements address many of the concerns that you've already heard today. For example, you heard, well, what about these folks that can come in and they can condemn a permanent right-of-way? They can condemn a permanent easement. They can take that from me forever, even though the wind facility, for example, only has specific or has a specific limited term. The answer to that is if you can no longer prove the necessity of the power line, in other words, if that wind generation facility goes offline and the power line is not necessary, you can't keep the land. You can't continue to use the property, and the take reverts back to the landowner. I could go on with all of the specific requirements, but ultimately, I think what's most important is that the legislature and the courts have recognized very clearly that good faith negotiation is a mandatory prerequisite to any condemnation. With respect to the previous speaker, the fact that a company came in and said, you sign this agreement or I'm going to sue you next week, you cannot do that. A company cannot do that under the Eminent Domain Act. They have a requirement to negotiate in good faith for 90 days. They're required to provide details about the project, required to give the landowner information that they can process to determine how the project may impact their operations. And you heard the guiding principle is greatest public good and least private injury. If a company had truly come and said, I'm going to put a pipeline in your front yard, and a landowner said, no, I'd rather you put it in the backyard, that is right there the essence of greatest public good, least private injury. Yes, it might cost a company more to put it in the backyard, to put it out of sight, but that's something that the Act already requires. Now, you've, again, the members from the House side have heard this already. And the question came up earlier, has eminent domain been used in the years since the moratorium lapsed in 2015 to condemn a collector system associated with wind generation? The absolute unequivocal answer to that is no. No company has filed a condemnation action in Wyoming since 2015 involving a wind collector system. The caveat is that the power of eminent domain, the right to even make the threat, is what is so important to this balancing act that we've described. A company and a landowner actually benefit when the threat of condemnation is made. And I know most everyone in this room is going to disagree with me on that, but let me elaborate. In 2013, the Wyoming Supreme Court issued an opinion in a case called Green Corps versus Barlow Ranch Limited. In that case, the Wyoming Supreme Court weighed the 2007 amendments to the Eminent Domain Act. With respect to former Speaker Brown, respectfully, when at the time before the 2007 amendments, just compensation was determined using a before and after appraisal technique. But your predecessors in 2007 changed the act and said, in addition to an appraisal, you can consider fair market value by looking at so-called comparable easements. So what does that mean? It means that if a landowner can find other examples of a power line easement, of a pipeline easement, of a road easement, of a surface lease, and they can demonstrate that that's comparable or similar to what the company is trying to take, the value as set forth in that agreement can be used as fair market value. Now, the practical implication of that is that ultimately every new agreement that is negotiated can become a new floor, if you will, for negotiation purposes for the next agreement. Now, why does the Green Corps versus Barlow decision matter? Because the Wyoming Supreme Court said if an agreement is made under threat of condemnation, or if the agreement is the result of a full-blown condemnation trial, then that amount, that figure, cannot be used as an indicator of market value. This seems counterintuitive, but that has been a tremendous blessing for the private property owners in Wyoming. And the reason is simple. A company can now trigger the protections of the Eminent Domain Act by making a, quote, threat of condemnation, and that frees them up to negotiate and offer far more money than they might otherwise be willing to do. Because again, it can't be held against them in a future proceeding. Now, what kind of results have we been seeing as flowing directly from this type of structure and this balance? Madam Chair, I apologize. I probably should have said at the beginning, you can tell I'm passionate about this. I am here as a partner of Holland and Hart, and I'm happy to be here. I am not here speaking on behalf of any particular client or any particular company or industry. And I should have said that before. But ultimately, excuse me, I have been reviewing a lot of the information that I have available to me after these years of working. Let me just give you a few examples of the kind of payments that are being made as a result of these condemnations or this use of eminent domain. I don't want to give anyone the impression that I am an appraiser. I'm not. I don't know the ins and outs of doing a before and after analysis. But after years of working in this space, I have a pretty good idea of what land values are worth. And generally speaking, especially here on the eastern side of the state, I think $500 an acre for ag land is pretty fair, pretty appropriate. Now, in some cases, it's going to be more if we're talking center pivoted irrigation or some other particular property. Well, I give you that as a basis so that you can understand the following. This is from a very recent pipeline agreement that was made in the midst of a condemnation. $4,000 an acre initial payment, $2,000 an acre annual payment for an oil pipeline. If you just assume a typical life of field of 20 years, which is probably on the low end, we're talking $40,000+ an acre. $40,000 for an acre of land that may be worth $1,000 an acre if you were to sell it in the ag space. Surface facilities are far more. Remember, the pipeline's buried. It makes sense that the compensation would be less. Surface facilities, $7,500 an acre per year. Again, a 20-year assumed life, $150,000 an acre is the kind of money that is being offered and accepted as a result of this balanced approach to negotiation. Road payments are a little harder. Stacked payments are the new norm. So if you're using the road to get to point A and then beyond that to point B, you have to pay for it twice, and they stack up indefinitely. $10,000 an acre is not unheard of for roads these days. And power lines are in the $6,500 an acre range, which is frankly the low end of the range. What does all that mean? I know I've been going on a while. I'll wrap up. It's a balanced and fair approach as it exists. It is a complicated system that has taken me 15 years to understand. It's not a good idea to start tampering with or adjusting because you never know what the ramifications are going to be. Let me try to touch on just a few of the questions I've already heard, and then I'll wrap up. Senator Kolb, you asked about precedent and whether or not the Eminent Domain Act has been challenged. The answer is absolutely. It has been challenged in the context both of the constitutionality and the validity of the act itself. And that was done historically in the 70s and 80s. It's also been challenged on a regular basis on a case-by-case scenario. In other words, challenging the application of the requirements and making sure, A, that they're fair and appropriate, and B, that they've been met. Senator French, you asked about just compensation and who decides that. The short answer is, after a court has decided whether or not all those prerequisites have been met, and in other words, that the take is allowed, The matter proceeds to a panel of 3 disinterested appraisers in the county. Those 3 disinterested appraisers weigh the issues, look at fair market value, do what is in effect an appraisal, and also look at comparable easements to determine what's been going on in the area with respect to other payments. And then they make a recommendation to the court. In my experience, the court always approves and accepts the appraiser's recommendations. That usually does not end the process, unfortunately. Once the court makes that decision, either party has the right to appeal the decision to the district court judge. And what that really means is you move to a jury trial where a jury from the county hears the evidence from both sides, usually in the form of expert appraisal testimony, and the jury decides what they think is market value for the part taken. Senator Hicks, you asked why did the past moratorium fail? I can only address the 2023 moratorium and our governor's veto. The short answer is he felt like the 9-year proposed moratorium in the bill, in the act, was too much. From his letter, he said a 9-year moratorium for wind transmission only would unnecessarily burden negotiations and curtail development rather than encourage developers to reach fair and reasonable agreements with landowners. His letter says much more than that, but that is one of the things that he said. Ultimately, respected members of the committee, there's so much at stake here that goes beyond the feelings or attitudes of a particular landowner. You've already identified correctly that this is a balancing act between private property rights and the rights to develop for the public interest the resources of our great state. This does not directly apply to wind, but let me just conclude with.
Yeah, I think we're going to have to start wrapping it up just to
I'm ready.
stay on our schedule. So if you just one final comment. Please.
Understood. Thank you, Madam Chair. My final comment is this. I looked at the rig count for oil and gas drilling rigs in our nation as of Saturday. In Wyoming, there are currently 15 oil and gas rigs operating. In New Mexico, there are 107. In Oklahoma, there are 43. And in our neighbor to the south, a state that very obviously is anti-development and anti-oil and gas, they have 17 operating rigs. Companies are taking their capital elsewhere as a result of some of the challenges that they see and foresee in the state of Wyoming. And so I would ask or advise and counsel to the best of your ability that we don't tamper with the existing very well-balanced act. Thank you.
Thank you very much. We appreciate your testimony. Are there any questions? Representative Banks.
Thank you, Madam Chairman. Now, my question goes to the landowner liability piece. Is, in your words, fair and balanced, okay for the landowners to have liability over the damages of projects on their property?
Madam Chair, Representative Banks, thank you for the question. Remember what I said about comparable easements? Thanks to the work that you've heard about from Mr. Phelan through Commissioner Wade, the vast majority of existing agreements include protections for the landowner along those lines. In fact, it's not even just protecting the landowner from what has been described as the addition of an industrial use to an agricultural property, but it actually requires significantly more insurance and other protections. Bottom line, the act has already evolved and its practical application has addressed that very issue so that any new agreement includes the types of protections for that liability so that it does not rest at the feet of the landowner.
Follow up, go ahead.
Yes. Thank you, Madam Chairman. And that's why I guess that we need to look at this is because you said some projects have that. I think it's this committee's best interest that we look so that every one of these has those protections. All of our landowners have these protections. And I guess I want to know your thoughts on having it all equal, so all our landowners are protected that way when we look into this issue.
Go ahead.
Madam Chair, Representative Banks, thank you. The short answer to that is essentially what has been touched on already with respect to private property rights and local control. The system as developed has protections that are triggered during the good faith negotiation process. It strikes me as counterintuitive that this body would want to interfere with the negotiations that go on between a landowner and a company or a project more than has already been done. And what I meant by some, I'm a lawyer. I have to couch everything I say in terms of some wiggle room. But ultimately, what I'm telling you is every new agreement that I have negotiated and been involved in the last 10 years has included exactly the kind of protection that you're referring to.
All right, further questions? Representative Slagle?
Yeah, my question comes to the statement you made about basically if a rate is determined during the condemnation, it can't be used in the future. So how is that beneficial to private landowners? I mean, if say I get a good rate, but then I can't share that rate with my neighbors, how is that beneficial to other people?
Madam Chair, Representative Slagle, the response is really quite straightforward, and ultimately it is this. The freedom that a project developer has to offer more money and to be more flexible and to be more generous, for lack of a better term, takes place in the context of either a threatened condemnation or an actual condemnation. But that is only a small percentage or portion of the overall agreements that are inked in our great state. And so what happens is, notwithstanding the limitation and as I put it, the freedom to offer more and negotiate openly, is that in those non-condemnation contexts, all of that is what is referred to as an arm's length negotiation. And those are all fair game. And at the end of the day, what we have observed over the last decade is that even those terms and conditions that are protected, if you will, under a condemnation are available, they're part of the public record, and they form a basis for future negotiations. I recently, in the last 2 weeks, inked a deal that was based almost entirely on a court decision that happened in another case about a year ago. And so that's what I mean, is it allows companies to be more generous with this comfort level of not being bound by it in the future, but the practical application is that information is available and is used in future negotiations.
All right, further, Chairman Eklund.
Madam Chairman, so I guess a question I would have is, in these negotiations over the easements, have you or can people who have land where collector lines are going on to negotiate for a periodic payment instead of so they would receive maybe the same benefits that the actual wind farm or where the wind towers are put? The collector lines do every bit as much damage, and those folks are never compensated. And that seems to be a real serious problem with the whole idea of renewable energy. Is that done, or can it be done? I'm curious.
Madam Chair, Mr. Chairman, thank you for the question. Certainly it can be done. Again, I think the bedrock foundation of all this discussion is good faith negotiations. And that runs both ways, by the way. It's not just a company, but also a landowner that has to negotiate in good faith. But ultimately, the bargaining power is, let me say it this way. Landowners don't like this, and I understand that. The question of whether a company has the right to take the property leans very heavily in favor of the company. Okay. The balancing act that has been performed puts far more benefit on the side of the landowner when it comes to just compensation. That's why I say $150,000 an acre for a surface facility is important to keep in mind. Now, ultimately, our state has decided from the days of the Constitution that there are some projects that are so much benefit to the public that we will take private property. We've made that decision. It's constitutional. So the protections and the balance comes in the form of how compensation is determined. And I mean, it is not an exaggeration to say I have been involved in situations where millions of dollars have been paid to the landowner for a temporary surface use. And so I hope that responds to your question, Mr. Chairman.
Probably not, but it would take a longer conversation. We don't have.
Maybe a sidebar over at lunch break. All right, any further questions?
Yeah, Madam
Senator
Chairman,
Hicks?
not so much questions, but just, your analogy of the cost of the land is illustrates the lack of understanding of the nature of the problem. Because the issue you didn't get to is what was the lost ability to generate a livelihood off of that 1 acre. In some cases, that's much more valuable than the actual exchange of selling an acre today and an acre tomorrow. You also didn't calculate in the cost of appreciation. We've got land that same analysis that you used was $500 an acre land 10 years ago, just sold for somewhere in the neighborhood of $50,000 an acre because of the proximity. So it's an oversimplification of the way you're portraying it. But the question I have is, I disagree with your assessment that the Green Corps versus Borrow changed the analysis and the landscape on how easements. And the question I have for you, did you or anybody in your firm lobby against the 2013 bill that Representative, at the times, Speaker of the House referenced earlier in his conversations? Because that's what leveled the field. Are you aware of that legislation and what that did? Because you didn't even mention it. And I would contend that that's probably the biggest reason that we haven't seen any collectors use right of eminent domain. Can you explain that?
Madam Chair, Senator Hicks. Yes, I can. Notwithstanding my passion, I do not like this. I would much rather appear in front of a single judge or even a relatively small jury. So personally, I was not involved.
More educated than legislators. You didn't need to say that.
Now
Go ahead.
Let the record reflect that I did not say, no, I'm just kidding. Ultimately, Senator Hicks, to answer your question, I was not personally involved, and I do not know, to be honest, if anyone from the law firm Holland and Hart was involved in the 2013 legislation. Yes, I'm aware of it. It's certainly as a part of my practice, I have, been aware of the legislative history of the Eminent Domain Act. And ultimately, I recognize I'm oversimplifying land values and that things change. What I hope to convey is not so much the specifics of one parcel or another, but just ultimately the hard work of determining this very delicate balance has already been done.
All right, Senator Kolb, and then we better keep on moving. We have others that want to testify. Go ahead.
Thank you, Madam Chair. Just a question. Is there any calculation for the compensation for the power flow through collector lines or transmission lines as they would go from, a different one facility to some other endpoint?
Madam Chair, Senator Kolb. The short answer to that is not that I'm aware of. There have been numerous negotiations in various projects where landowners have requested a sort of throughput value. And ultimately, there's so much uncertainty involved in that it, to my knowledge, has never happened. The negotiations tend to focus more on the value per acre and on whether or not annual payments will be made.
All right, thank you. Follow. Go ahead.
Thank you, Madam Chair. So that was my question about court precedent, was particularly about collector lines. Okay, that was what the question was. So and that's all right. I'm just gonna make a point here, is that if you're compensating for flow through a pipeline and there's some sort of value given for that exchange or that transmission, I don't see why you folks couldn't then be all right, I guess, maybe a change, but with somehow that calculation being put in the equation for that right of way for these folks that do not have the facilities physically on their facilities, the wind generation or whatever it may be. And that's just, I guess, my last point. Thank you.
All right. I guess you're off the hook. Thank you very much. Appreciate you being here today. All right, next up, name and if you're representing someone or yourself, please. Welcome.
Chairman Steinmetz, senators and representatives. I'm Dan Cushman. I'm a rancher in Niobrara County. My family has been in ranching since 1852. Starting out in south of the border down here in Colorado. Don't hold that against me, please. Couple of things I wanted to touch on. I want to make a quick comment on the previous speaker's analogy of the amount of drilling rigs. The amount of drilling rigs here in Wyoming is greatly due to the amount of federally owned land. That affects it more than anything else. If the state of Wyoming could get back in line with taking back our federal lands to the state.
Yes.
Mr.
Cushman, I just wanted to let you know, so if we start debating back and forth what everyone else said, we'll be here all day. So unfortunately, we don't have that time. Okay.
Quick comment.
Thank you.
On the Pronghorn Wind Energy project up here, a little bit of clarification on that. There's a large block of state land up there that they're looking at where they can put all this on that state land. The landowners around it, as far as I know, have not received any notification or anything that they're wanting to use any private lands around that. So I kind of question the amount of percentage of state land and private land that will be involved in this. I'm here representing my parents, Harley and Dolores Cushman. They own a ranch directly adjacent to these state lands. In fact, where their house is, it actually almost surrounds their house and property. Compensation to surrounding landowners. I would like very much for the state to look into compensation for neighboring properties, especially in this wind energy thing, the viewscape, the loss of value. This is greatly affecting surrounding landowners. In the oil industry, if you have a 40 next to a 40 that's been drilled on, there's compensation paid for that you're taking from underneath the surface. Why isn't it done with wind energy as well? It would make sense. And you're taking a great deal of value with these wind energy projects from the surrounding landowners and even the neighboring landowners past that. So a rate of compensation for that would be greatly appreciated if it was looked at. My parents are in opposition to this, and I have some copies of their letter that I'll submit to you, Chairman.
Okay, thank you.
And it just, the whole thing is a little bit questionable. It starts out based on this hydrogen project and them needing it for that. But they haven't applied for anything for the hydrogen project yet, or that development. Some of it's kind of questionable. And, it'd be interesting to have the state look into just what's going on. They hold grazing leases on a large amount of this state ground. It's about half of their property that they run on. The adverse effect to that state land up there, it's very fragile. It's short grass prairie. And there are sage grouse in the area. So, you know, it's several things there to look at. And I was just wanting to comment on that, and then I'll submit these to you.
All right, thank you so much. You can give them to our staff and Katie will take care of it for you. Yes, thank you very much. Appreciate your comments. Next up, just give us your name and who you're representing today. Welcome.
Good morning, committee. My name is Karen Bud Fallon, and I guess since my husband's not here, I am representing Frank Fallon in this discussion. I appreciate you not saying bad things about him. I don't want to get into a tit for tat with the other attorney that was up here. I'm also an attorney, but for every lovely light story he can give you, I can give you one on the opposite side. So I disagree that the eminent domain statutes are set up as fair to the landowners. There is absolutely truth in saying that if I can't say no, my negotiating power is less. That is just how it is. And we have seen cases in Wyoming where the good faith negotiation is a company sending the landowner the lever, waiting 90 days, never calling the landowner, never talking to him. They send him a letter, then they go to court. So I would argue that I think that some of the statutes need to be updated. Now, I do have a copy of the governor's veto letter that I can give Senator Hicks. You'll have to excuse the notes that I wrote on it, but it was just so that I could kind of remember what it was. But it was correct that he was mostly concerned about the time frame of the moratorium. He did say other things in here. He did say that he was opposed to strong arm negotiation, but it really seemed to me that his concern was the time. I don't think that gets to the whole issue, though. And I'm not arguing whether solar and wind is good or is bad or is subsidized or it's not, or it's going to take over coal and oil and gas or it's not. I don't think that's the issue here. Private landowners, though, have the ability to negotiate with wind and solar because they don't have condemnation authority. And so those companies have to make it worth the landowner's time and money to put up those projects. The problem comes, though, is that because there is condemnation authority for the collector line, which is the line that goes from the wind tower to the transmission line, that's where the problem comes. When you look at the big transmission lines that go through, most of those either have to go through the PUC or FERC. Those are public processes. So that a landowner can get in, they can object, they can appear before the Wyoming Commission, they could appear before the FERC and be able to make their concerns known. When you're talking about condemnation for a collector line, there's no process unless you hire an attorney and go to court. And the other problem I see with that is that wind and solar require large tracts of land. So when you're talking about a wind farm or you're talking about a solar farm, it's not just the little guy that's got a half a mile of a transmission line or collector line going across his property. These are big blocks of land. So they get the solar farm proposed, and then they've got to cross 37 little guys for half a mile or whatever it is to be able to get to a transmission line. And those little Wyoming citizens don't have the ability to say no. And quite frankly, they're never going to get paid enough. Even with the protections in the Barlow case, you're not going to get paid enough to hire me because I'm sorry to say I'm also an attorney, or you're not going to get hired enough to hire Representative Crago to be able to represent your interest in court because you're not going to get paid enough and you don't get your attorney's fees paid. And so it's those people that are being hurt, which is why I think that we need to really look at the eminent domain statutes. I didn't realize there was going to be such a time constraint. So I do have a longer letter that I'm happy to present to the committee. But I do have some ideas on maybe what we could do to look at the eminent domain statutes in Wyoming. For one thing, I believe at one point when we were working on this, and I don't think it was the 2013 legislation, but it could have been some of them, we talked about, say, a 90-10 rule or an 80-20 rule, which would require a company to enter into good faith negotiation and actually have a fair contract with, say, 80% of the landowners along the transmission line or the collector line. And then if you just have that one guy that's like, no, not in a million years, you could use condemnation on him. But at least you would have a large percentage that had fair negotiation, that didn't have this hammer hanging over their head saying, we're going to condemn all of you. We hope you're happy. So that was one of the things. And maybe that was in the 2007. I can't remember. I just remember the discussions at one time. Another idea I would have is to require the amount paid for the collector line to be based on what the company is paying for the wind tower or for the solar. Because like I said, there's no power of eminent domain for a solar farm or a wind farm. So those are legitimate discussions about value. And quite frankly, the values that I've seen, because we only represent landowners. We don't represent the companies. We represent the landowners, and the amount of money a private landowner gets for allowing wind towers on his property will pay a lot of debt and buy a lot of cows. But the amount that the guy gets for just the little line is not very much. And so maybe there could be a formula to say that whatever you pay for a wind tower, if you can negotiate that out, part of that ought to go to the guy that's just got the transmission line on his property. Another idea is to set forth minimum requirements for a contract in statute. So for example, you would say, okay, as a minimum matter, we have to deal with this liability issue the Representative Banks raised. It is true that when we can negotiate contracts, and quite frankly, our firm was the one that pioneered this, we try to limit the liability for the landowner, because what happens, and we actually litigated a case on this, is that there was a pipeline across some property out near Evanston. And the pipeline wasn't being managed right, and somebody turned on a valve and a seam broke, and you had gas spilling all over a rancher's field. And the rancher ended up foisting most of that cost because the pipeline was in a limited liability company. And so the only time the landowner could go against the liability company was for the value of that pipeline. It was Bridger Pipeline. And so he wasn't going against somebody that had a lot of money to fix it. He was going against this limited liability company. And even though that Bridger Pipeline segment was part of this much bigger corporation because of Wyoming's limited liability statutes, that's all there was. This guy lost hay production. This guy had to go in and gather up dirt work. And in the middle of all this, the pipeline company went bankrupt because they couldn't afford this. And you know who was stuck with the problem? It was the landowner. And so one of the things that I think is if you created like minimum requirements, then certainly the landowner and the company would be free to negotiate for higher than the minimum requirements. But if you've got a condemnation, at least then you would have a minimum protection for liability. You would have minimum sort of default protections for things like abandonment. You would have minimum default protections for things like attorney's fees. You could have things like in the easement about the number of connector lines in the easement, or what goes under the easement, or what happens if an easement gets struck by lightning, or the power line gets struck by lightning. So I could help you come up with a list of those minimum requirements that we have negotiated now, so that maybe at least the landowners, at least at a minimum level, will be protected if there's condemnation involved. Somebody asked about going through federal land. I guarantee you that it's better to go through private land with condemnation than it is to go through federal land. Period. End of story. And I can show you maps. We've got maps at the office where lines will go in all sorts of crazy zigzag motions to go around federal land because of NEPA, because of the archaeological clearances, because of all that other stuff. So it's much easier to just condemn the private property, which is why I think eastern part of Wyoming is going to be pipeline transmission line heaven. And it is. You talked about the pronghorn issue, and I do want to say this. They are negotiating, Jason was right, sorry, Mr. Assistant Director Crowder was correct. But it is absolutely connected to this issue, because if those wind towers can get built, then pronghorn is going to have the ability to condemn private property to get those collector lines to wherever they're going to go. And so that is going to be an issue for eminent domain. It's not just whether the state agrees to allow the wind towers or not on the state land. I think one of the things in the statute is that it does not define good faith negotiation. It says you have to send a letter. That doesn't mean that they're going to actually try to work with somebody. And when you're only talking about a very small portion of a line going through a half a mile or a quarter mile of somebody's property, they're not going to work near as hard at good faith negotiation as they do when we can create a landowner group, or when you're talking about a wind or solar farm. As I said, I had a lot more background and a lot more points, but I know that you're running out of time. So I will put this information together and send it to your staff so that you can have my several pages of written comments, because attorneys don't do anything short at all. And I would stand for questions.
That would be great. Thank you so much. Questions? Any questions? Senator Hicks.
Karen, on your 80-20 analysis, how do you factor in, particularly on long linear disturbances, aka maybe a pipeline or even a main transmission line, the differences in values as you transition from one landowner to another? Because they can be, sometimes very short distances can have tremendously different values, economic values attached to that land. How do you then address that issue under an 80-20 scenario that you proposed?
Go ahead.
Chairman Steinmetz, Senator Hicks, I haven't dug deeply enough into it to try to figure out how the formula would work. I was just trying to think of ways to force the companies to fairly negotiate. I do understand that if you have the one obnoxious holdout landowner who would have been like my father, that it would have been harder. But what I'm trying to think of is a way, because I mean, some people argue that the companies, will never take advantage of all these landowners, and that in my 35 years of being an attorney is simply not true. And so maybe the 20/80 or 90/10, I can go back and pull my old files because I absolutely remember that discussion. We had that discussion. I was testifying in front of a group in Rollins when we had that discussion. And so I will go back and look and see if I can't find that old bill or that old discussion, and I will be happy to provide that to you.
Thank
I'm
you.
just afraid under that scenario, it could undervalue a landowner that has a lot higher, another amenable assets. So an example would be is say they make a significant amount of revenue off their recreation, whether it be hunting or some other component that the guy out here does it, and as you move in here, you do, but you're only going to give him compensation, but yet it impedes his ability to make a living off of that land. That's the biggest thing. I try to grapple with the 80/20 as to whether that's even feasible.
Okay.
From a compensation standpoint, but maybe the way to do that's getting back to that draft statutory, the minimum things that have to be required to be addressed.
Okay. As I said, Senator Steinmetz, I will go look and find my old notes and see if that was addressed or not. And maybe that's not the route you want to go. I just think that the current route we have is not protecting Wyoming small landowners.
All right, thank you for that. Representative Winter and then Chairman Eklund.
Yes, thank you, Madam Chairman. Ma'am, could you give us an assessment, if it's possible, of the what I think is an injustice provided to the private landowners that Mr. Cruzy explained about earlier this session, about how they were, I would say, abused by these companies. Do you have any thoughts relative to that situation?
Go ahead.
Madam Chairman, Representative Winter, my firm is actually the firm that got rid of the Etsy pipeline, which did take a lot of money because the pipeline was never built, but that easement stayed on those landowners' property. So even though the pipeline was never constructed, the easement was there, and we had to file abandonment. It took about 6 months and quite a bit of attorney's fees to make that thing go away so that the landowner's property was free and clear. And basically what the line was is that this Etsy company was going to build a pipeline across their properties. It did come up with fair negotiations on part of it to connect the line. They went in and did argued for condemnation on the rest of it, and they never built the pipeline. The landowners that did not agree to the amount that they were given were not given very much money. And the bigger problem with that easement is that it was an unlimited easement. And so what the landowners were concerned is, okay, so Etsy now sells that easement to some other company who then puts a different kind of pipeline in there that the landowners were not ever suspecting or didn't know anything about. And they were going to be stuck with that easement. And that easement did not protect landowners from liability. It did not have standard reclamation requirements in it. There was all these other things that weren't included in the easement. And so we had to sue to get rid of the easement because they didn't want something else being built in an easement that they were just stuck with forever.
You good? Representative Winter?
Yes, thank you, Madam Chairman. The way I understood it, they've not been compensated for the damage that they received out of that whole operation. Is that correct?
Madam Chairman, Mr. Winter, so when they initially bought the easement, the landowners were compensated at that time. If they would have sold the easement, there would have been no additional compensation and none of those other protections for the landowners, because the easement is there forever. And so that easement was old enough that what they paid those landowners for that easement was pittance, which happens with a lot with the old easements. And the problem with those old easements is we are getting smarter about negotiating them. But a lot of those old easements we see in Wyoming don't limit the number of lines that can be put in the easement. They don't require minimum reclamation fees. They don't have all these other protections that we're now getting smart enough to negotiate when we have the chance to negotiate.
All right, Chairman Eklund's next, and then Senator Ide.
So I think it'd be quick. So in order for a landowner to be paid a periodic compensation for the collector lines, just as if it's the wind tower itself, we would have to pass legislation probably to fix that problem.
Well, it depends. You can negotiate for whatever you want. And so when we have the chance to negotiate these lines, often we will request periodic payment or payment based on the wattage that goes through the transmission line or whatever. And so we can negotiate whatever it is. That's not included in a condemnation effort under the Wyoming condemnation statutes. All it is supposed to be, quote, fair market value. And so that's not included under Wyoming statute if the company is going to condemn.
Okay, Chairman, so we'd have to have statute
Yes.
changes to fix that part of the problem. Thank you.
And I trust our staff is taking copious notes of our discussion. All right, Senator Ide.
Thank you, Madam Chair. I hate to always keep coming back to this, but from a legal standpoint, you representing landowners in our statutes. Would you agree that part of the litmus test of even entering into negotiations should be, is this commercial without taxpayers' subsidies? And, you know, it seems to me like we're fighting their lawyers with our own tax dollars that they're getting subsidized with. And would you comment on that? Thank you.
Go ahead.
Madam Chairman, I always have to remember to do this part. Senator Ide, I will tell you that many of the landowners we represent would 100% agree with you, especially when you're looking at wind and solar, because without the subsidies, it's not viable. Now, when you're actually talking about the farm, though, those do have to be fairly negotiated, and subsidy or not, those landowners are getting paid. It's the transmission line, and right now in Wyoming statute, that's not looked at. As a philosophical matter, and I don't know that I think this translates well to Wyoming law, I completely agree with you. You are spending your money, but every time that an environmental group sues the federal government to make them do something, they're spending your money too. So I think the whole thing is an issue that somebody ought to look at.
All right. Okay, are we good, committee? All right, thank you so much.
Thank
Could
you.
I, at this time, just have a show of hands of how many more people want to testify on this subject? Okay, one Farm Bureau, so come on down Farm Bureau, and then we'll go to stock growers. And then as soon as we're done with that, we are going to take a 5-minute break, and then we'll have a great brief update from our good state lands office about the state of our current legislation we passed last year, how we're progressing on being ready to move forward with that. And so go take it away. Take us to the home stretch, boys.
Thank you, Madam Chairman. Jim McGagnon with the Wyoming Stockgrowers Association. It certainly brought back some memories listening to Speaker Brown talking about this. We worked very closely together back when the original moratorium was put on. Everyone's intent at that point was that we needed 2 years to sit down and work together to resolve this and come up with legislation that could work for everyone. And then the push for wind energy sort of dropped off, and that was not accomplished, and that's why we're all here today. So my one plea to you as a committee would be, please do not just put a moratorium for X number of years again. I think this issue needs to be resolved, whether it's resolved by removing eminent domain or by putting some constraints on it is obviously going to be up to you as a committee, but and future legislation can change that, but I don't think we should just put a time-limited moratorium on it again. I provided you with a copy of some draft legislation from 2013. I was thinking that was never actually introduced. I could be wrong on that, but at least according to my records. And it does some of the things that were just talked about. It has an 85 before an entity is entitled to use eminent domain for collector lines. They have to have already signed up 85% of the landowners that would be involved and 85% of the acreage that would be involved, so that you're just getting down to, as the previous speaker referred to, maybe that one ornery landowner who's keeping all the others from benefiting. And I'm not defending the 85% necessarily, but I think there's some merit in looking at that. More recently, I'm aware of some instances where, in fact, at least one wind energy company has come along and has agreed to annual payments to the landowners with the collector lines. I'm also aware that, thinking way back, the old saying used to be the only way to assure your success as a rancher is to have an oil well in the middle of your property. Well, unfortunately, and from my view, but for some landowners today, that oil well is a wind farm. And it does provide some economic return to them with some inconvenience to others. They should not be able to have that at the expense of other landowners who have collector lines on them. But if it can be done in a manner that benefits all those people, then we would maintain that an individual landowner who happens to be disgruntled for whatever reason shouldn't be able to deny that economic opportunity to a whole host of other landowners. So I think something along the lines of this bill might be a starting point to address this issue. It also provides that there must be a willingness to negotiate annual payments. And several of the other suggestions that the previous speaker made, I think, could be incorporated into a bill like this and make it something that, in fact, could work well for landowners going forward and perhaps be more fair to everyone, including the landowner community, than just the 100% outright prohibition. So I would encourage you to take a look at something like this. The only other point I would make in the interest of time is that I think this particular issue with regards to collector lines needs to be addressed in its own legislation at this point in time. It's hung on for too long. It's really an active thing today, and to try to draft a bill that hopefully can relatively easily move through the legislative process focused on collector lines. The broader issue of eminent domain and how it's being used today, I was also very involved back in 2007. We worked closely with the Petroleum Association Wyoming to develop the changes that were brought in then to the eminent domain laws. And I think they were certainly improved those laws for the protection of landowners. A lot has happened since 2007. And one of the things that certainly I see today is that not all, but certainly many of the companies that are involved in development of pipelines and things that may use eminent domain or may have the opportunity to use it have changed. They're not the more local companies that existed 20 years ago, or at least companies that had much more of a local presence, local relationships. And I think it's being done more on a corporate business basis today, with not necessarily all of the relationship building that we knew back then. So I'm certainly not going to say that there isn't merit in perhaps looking at the broader eminent domain laws. I think that's a much bigger process, probably more than a 1-year process, frankly, and something could be undertaken, begun, but would need more time and more opportunities for public input. And I would offer, if the committee is interested in it, back in 2013, we at Wyoming Stock Growers had asked the Rural Law Center at the University of Wyoming to prepare an analysis of eminent domain and recommendation for various ways in which the eminent domain laws could be strengthened from the perspective of the rural landowner. The result of that was a 68-page document that I have here with all kinds of suggestions. If you decide to take up the broader issue, if you wish, I'd be happy to make that available to LSO and to the committee. With that, I would welcome any questions that you might have.
All right, thank you. Senator Kolb.
Thank you, Madam Chairman. I have a broad question. What is your opinion on view sheds and degradation of that value? I mean, it's just people's opinion, of course, but as it pertains to tourism and basically the custom and culture of the state of Wyoming, when you do these large projects, is there any consideration given to that?
Madam Chairman, Senator Kolb, I think in county planning and zoning and things that can be given consideration. The thing that I really struggle with, and we went through this with the wind energy project in Albany County, south of Laramie, that we supported very strongly. And many of our members were involved in that. But, at what point does your right to protect your view shed interfere with my private property right to do what I want on my property? I mean, there are obviously some things. There's zoning, there's setbacks that need to be in place. But at some point, if I can say I don't want to see wind towers out on that piece of land, then I can also say I don't want to see cows out on that piece of land. And if we start down that pathway, it can very easily and quickly, with some of the interests that are around today, become so far excessive. So I think we need to be very cautious in that area, but not be blind to the fact that there are view shed types of impacts.
All right, I don't see any more questions. Thank you, Mr. McGagnon, and I would love to see the document regardless of whether we take it up or not. So
okay, I'll be happy to provide that.
and thank you for the 2013 legislation. We've talked about it a lot today. So, all right.
Thank you, Madam Chairman. Brett Moline, Wyoming Farm Bureau Federation. One thing I want to say that right off the bat, that some companies having the power of eminent domain makes it so the playing field is not level. When you're the only one in the room with a 5-pound sledge and everybody else has just got fingers, you know who's at a disadvantage. So I think our past work has made it less bad. I'll never say it's made it good, but it's made it less bad. It's given more power to the landowner. I think there's 3 different areas that I would like to have this committee take forward. Part of it is the term of the easement. I find it a little ironic that, government doesn't have to give a perpetual easement like the private landowners do. I find that, I'll use the word ironic, that private property rights aren't as powerful as the public land rights. So I'd like to look at that, to make that more accessible. I know the companies don't like it. In the short term, might devalue the easements, but in the long term, I think it will add to the value. The value of the easement right now is going to be a lot different than the value of the easement in 30 years. We found that out with 2 pipelines that went through my family's ranch. Another area is liability. Why should a private landowner have liability? And I know we can write it into the contract for the pipelines that went through my family's property. That was one thing they got in there. But I just don't understand why somebody else putting something on my property increases my liability. That should be borne by the company that put it there. So if somehow we can answer that question. And I'm very intrigued. I'll have to study it farther, but I really appreciate the concept that Chairman Case brought forward, that do these companies, the collector lines, do they truly have the power of eminent domain? gut feeling is maybe they don't. But I guess the question becomes, should they? And that's where it'll take legislation to answer that question, if they should or shouldn't. But I think, the biggest thing, public goods are extremely important, but I don't think they should supersede the value of private property. I think private property should be above the public benefit. And with that, Madam Chairman, I would sit for any questions you or the committee may have.
All right, thank you. Committee, any questions for the Farm Bureau? Seeing none, thank you very much. And that will conclude our public testimony on eminent domain. We will take a 5-minute break and be back in 5 minutes.
The Senate 5-minute break.
All right. So I've been informed the Senate has a longer 5-minute break than the rest of the world. But thanks to our herd dog, we're all back. Before we get started, oh, I guess that's what this is for. All right, we're official now. Before we get started, I don't listen to him anymore. Before we get started, the Chairman Eklund and I were visiting, and we were thinking that we might direct staff to go ahead and draft up the section provided to us by Chairman Case for draft legislation, and then also the bill provided by stock growers, the 2013 bill. And we'll have something to springboard off of at our next meeting. When we get those ready to go, we'll have some email exchange back and forth with the committee. And that way we can be developing our thoughts for the next meeting. So absent any objection, that's what we plan to do. And that will give staff some fodder for our fire. With that, welcome State Lands and Investment, and thank you for your patience today. Aren't you glad when people have so much to say that it leaves you very little time to? Anyway, I'm kidding, joking with you. So we would like to have a concentrated update on what our legislation did for you last year, how the office is looking at implementing that. If we're seeing any hiccups that we might be able to have some, tweaks that you might see that might need to be made or not. We do have 2 bills that are being drafted by our good staff now that would change the postmark date as that being the received date for your office. So that would give you more flexibility. And also, we will be looking at the 30-day grace period at the discretion of the director for extenuating circumstances. And so those are 2 bills. I don't know that I've had the time to visit with the committee about that the governor's office brought to our attention due to some issues that happened during a snowstorm and other things that I'm sure you'll touch on for us. But we are hoping to get out of here around 12, let's say 12:15 or so. And we appreciate your patience with us. So thank you.
Madam Chairman, for the record, I'm Jennifer Scoggin. I'm the Director for the Office of State Lands and Investments. With me, you folks have spoken with Deputy Director Crowder earlier today, but we also have Holly Kennedy. She is our Assistant Director for the Trust Land Management Division. Madam Chairman, since you first asked for an update on what we've been doing in the meantime since the legislative changes from the 2023 session, I'll start with that. And then given the time, we thought we'd just go through a couple of quick slides from our PowerPoint that we had presented to the committee, just to kind of highlight some of the revenue and some of those things in case there are some questions. So first, Madam Chairman, we are in the rulemaking process. The legislative changes don't take effect until July 1.
Correct.
We have opened Chapter 4, Chapter 26, Chapter 5 and 6 to make sure that all of you may recall the notice requirements for RFPs and that sort of thing. Those also touch not just special use leasing, they also touch wind energy leasing and things like that. So we had to add to some of that. The cure period, that's being added on to Chapter 4. We did have a working session where we invited stock growers, Farm Bureau, and some others to participate. And I think some of the legislators were invited as well to provide comment. I'll turn it over to Deputy Director Crowder to give you a little color on the working session. Go ahead.
Thank you, ma'am. Thank you, Madam Chairman. It was a good working session. I want to thank everybody who came. Like the director mentioned, Farm Bureau, stock growers, Representative Davis came. It was good, well attended, I guess. We had great treats and coffee. So thank you for coming and taking advantage of those. We had a good conversation as well. It lasted much longer than I think we anticipated the conversation to go. And a lot of good thoughts were shared, both from the limitations that possibly OSLI has to their expectations or hopes and wants from everybody else in the room. So we had a great understanding of where those are, had a discussion of how to get over those hurdles. And I think that where we landed with the draft set of rules that is currently in its emergency form approved by the Board of Land Commissioners and then open for public comment, like the director mentioned, is a result of some of that. And while we didn't or weren't able to put everything in there that the discussion may have tried to put in there, we do know that there is a need to update in some areas, and we feel some of that need lies with the legislature. Further work with you all to change some legislation, as you discussed, Madam Chairman, to create some more flexibility to bring in those weird situations and clean them up quickly and efficiently, but also bring our office more into the 21st century as far as electronic submission of not only applications and payments. And some of the reason why we weren't able to move forward with those rules right now is that those have broad implications, not only with the budget of understanding that we need some programming to get that done, but we need this across the whole agency. And as the director will go through here in a minute, that type of change is broad across the whole agency, meaning we need to understand how it impacts not only the grants and loans, the subsurface piece, the field piece, but also the grazing piece, and pull those all together at once. I think one thing that we did have a great conversation about at that working group is that we recognize that and that we are focused on moving forward in that direction. So even though it's not in this set of rules, it doesn't mean that the office isn't moving forward with it. And again, a great conversation, and appreciate everybody that came.
Madam Chairman, if I might, we'd just like to scroll through a couple of the slides from the PowerPoint. Slide 9 first, Jason. Sorry.
Because we can't see your slides.
They
And
should
so
be in
we
your
need to
materials.
get in our packet, and you'll have to tell us which I wanted to thank you, by the way. This will be a great basis for a packet on your office. And so don't think that we haven't read or that we don't appreciate the information. But if you could tell us which of these little booklets it's in and what slide you're on, we can follow along.
Madam Chairman, it's in the PowerPoint, the one that has yes, that one, and it's
Okay,
on,
everybody, this one?
yep. And it's on page 9, the
Okay.
grant programs.
Okay,
And this is just a table. A lot of times people forget that we do more than just manage trust land resources. We also are the staff for the State Loan and Investment Board, which takes up a bit of our time too. And the State Loan and Investment Board, they manage a lot of the grant and loan programs for the state. And so I wanted to give the committee an idea of what some of those grant programs are. And in the last couple of years, it's been very hectic given ARPA and CARES to deal with the pandemic. So this slide just shows the main grant programs that we administer, gives an idea of the number of grants that are out there and the available balances in those. At some point, I'm happy to explain what each of those grant programs are, or feel free to call Elizabeth Blackwell in my office. She is the expert on all of this. With respect to ARPA, as you can see, there were a number of appropriations, both in the 2022 legislative session, and then additional funds were added to those 3 programs in the 2023 legislative session. And just suffice it to say that we received hundreds of applications, oversubscribed to the maximum amount, if you can believe that. There were a lot of special meetings for the SLIB board to go through these applications and make those awards. We still have some work to do, particularly for those 2023 appropriations for inflation-related costs in the HHS, and for the local governments. We'll be able to take some additional new applications for that, as well as I think there's a $5 million set aside in the local governments for unmet housing needs. We're hoping to roll those out this summer. Need a little more time to get going on that. And then I just wanted to mention the CARES Act, and that was obviously earlier in 2020. But we also had hundreds of applications for those funds. 600 CARES applications between July 2020 and November 2020. And that resulted in 7 SLIB meetings to award those funds. And 4 of those were special SLIB meetings. So you can see that those grants for the ARPA funds, and CARES has taken a substantial amount, at least of the financial side of the fence's time on the SLIB, for the SLIB.
Could I ask a question on that?
Certainly.
So with the latest debt ceiling bill, is any of that money going to have to go back to the federal government? Do you have any idea, or what, is this unaffected?
Madam Chairman, it's our understanding in working with our Attorney General representative, we've been reviewing all the clawbacks and things, but it's our understanding that these funds will not be impacted by that.
All
So
right,
we are
thank you.
planning to go forward with those.
Thank you.
Okay, Jason, to the loans, please. So in addition to the grant programs, we also manage a number of loan programs. And this is a list of the loan programs. There were some changes in the 2023 legislation, which removed the student dormitory loans and the Joint Powers Act loans, but essentially made the entities eligible for those loans, rolled that into the capital construction loan program. The Aeronautics Commission, Hot Springs State Park irrigation loans, those are all programs that have been repealed, but we still have loans in repayment on under those programs. Then the farm loan, beginning ag producer loan, the amount available for that loan program was decreased in 2023, and there was an interest rate adjustment. Previously, the farm loan program and beginning ag producer program, the farm loan program was thought to be a safety net for when inflationary times, when interest rates go really high. The interest rate under the farm loan program had been 8%. And then the beginning ag producer was a lower rate, but after 10 years would revert to that 8%. Now it's more in line with interest on loans equal to yield on the U.S. Treasury security of the same duration of the loan. The board can add a percentage not to exceed 2% as a risk premium, and the interest rate for all loans under that program can't exceed or can't be less than 3%. So it's a little bit of a different program now. So Jason, next slide. And here's a couple of additional loan programs. We administer the solid waste cease and transfer program. Then we've got the Clean Water State Revolving Fund and the Drinking Water State Revolving Fund. Those programs, the last two, the Clean Water and the Drinking Water, those loan programs are funded pursuant to capitalization grants through EPA. The state pays 20% of a match in order to get those funds. You'll notice that we have quite a lot of those funds available. We struggle to get those funds out mainly because we are a rural state with small population. The drinking water program funds a lot of public water systems, clean water, everything from sanitary sewer treatments and collections to stormwater control. There's a lot of uses, but we've also seen a decrease in utilization of those state revolving funds because of the amount of ARPA money that's available. People want free money, if you will. They don't want to take loans. So we are in the rulemaking process for those two programs to try to make those programs more palatable. We are going to offer 0% interest rates in some cases. With some of the new federal legislation, we may be able to use some of the funds for grants, for additional principal forgiveness and things like that. So, and also with the drinking water, we've got the IIJA funds coming for lead lines and supplemental funds and emerging contaminants. So, okay, Jason, if you'll run us down quickly to the total revenue, slide 45. So this is toward the back of your materials. Keep scrolling. There should be a bar graph. All right, there we go. There we go. Okay, we thought the committee might like to see kind of the total trust land revenue projection for fiscal year 2023. It's the one with the green bars on it. Right now, it's projected to be $216,259,349. You can see from the report here that we're trending in the right direction again. There was a significant downturn between 2020 and 2022, largely related to COVID. We had negative oil prices. You might recall that the oil and gas industry kind of went idle in Wyoming. So, revenue generation was difficult during those times. But now that we're seeing oil and gas prices rebound, our revenue projections are also rebounding. Jason, next one. So this graph kind of breaks out by the types of revenue. So you can see, obviously, the most revenue comes in the form of mineral development, which are those blue bars. Other trust land revenue in the yellow bars, those account for about 15% of the revenue. Grazing's contained within the yellow bar, if you will. And the thing about grazing is it occupies a lot of staff time, but in the scheme of it, doesn't return as much clearly as oil and gas development does. But again, you'll see that that's consistent with the graph I just showed you, that revenue is trending in the right direction. So Jason, next slide. And this pie chart, it essentially brings out, this is non-mineral. It is essentially the breakdown of the yellow bar from the previous slide for this fiscal year. The trust land leases, that big blue chunk there, that's grazing and special use leases. However, that number there does not account for most of the major grazing lease payments that come in December. You can see the other revenue that makes up the rest of the trust land revenue, rights of way and easements, surface impact payments, temporary use permits. Okay, Jason, next one. With respect to mineral leasing, as I mentioned, it brings in the most revenue of the 216 million. About 25 million total is all mineral, or it's mineral revenue like Trona, that sort of thing. But oil and gas brings in the most with 174 million and change. Wyoming ranks number 9 in the amount of money spent per pupil nationwide. And that is the fact that we help fund K through 12 education. That's a big badge of honor that we take into consideration at OSLI. We're always looking to increase those numbers. We are proud to help current and future generations. Okay, Jason, the last slide that we really wanted to highlight is the grazing and agricultural leasing report. There's been some misinformation sort of out there about the renewal rates for agricultural leases. This year, we had a spectacular year of a 96% renewal rate with our grazing leases. So only about 15 were not renewed for a variety of reasons. You'll see that maybe we didn't receive any application, late application, something of that nature. We aren't proud of the number in 2021, which is 86.5%. That was, of course, during COVID, where we had people that were teleworking and we had problems with the mail system where the US mail wasn't running, or we had mail sitting at the main state mail where they weren't delivering to the agencies and that sort of thing. And so we did do an audit from that year, and we were able to renew a lot of those leases and kind of sort of stretch and give as much of the benefit of the doubt as we could. But generally, we like to see it where, in the high 90s. And even beyond, if we could get 100%, we wouldn't mind that, because obviously to have the leases go vacant, that takes up a lot of staff time and resources that, we just don't have. If we can help folks renew, we do. We make phone calls. If we haven't seen their lease applications come in, we do our best. It's imperative, though, for people to make sure that we have their most recent information in our system. We've had some problems with bad phone numbers, no email addresses, which create some problems in our inability to contact people to get the extra information we might need to kind of push it over the line before the renewal deadlines. So with that, Madam Chairman, we would stand for questions. We just wanted to highlight a couple things for the committee. And I know we gave a lot of information, but we would be happy to answer any questions on that or come back to the next meeting in a few months and happy to answer it at that point as well.
All right, thank you. Questions from the committee?
Madam Chairman.
Go ahead.
So the question I'd have pertains to the new legislation. Will it affect another COVID year, will it correct some of the problems we had in COVID as far as lease renewals and the problems we had 86%, about 10% less than most of the other years. Will the new bill, if we land into another COVID year, fix some of the problems you ran into?
Madam Chairman, Mr. Co-Chairman, it might fix some of them. You know, some of the issues focused around people didn't realize that their application wasn't complete or something of that nature. And when you have to send a certified letter, we would obviously notify people of that. But it's not going to cure everything. Inevitably, we have people that we can't make contact with, or we have a bad address for, or we make phone calls, whatever. It's a tool. And while, like I said, we'd like to get 100%, I think in for some problems we've had, even in this past year, it would have helped, just because we'll send a letter, but really we want to when we're renewing, we want to do things quickly because we know timelines are coming. So it's a lot easier for us to make a phone call, to email somebody, as opposed to sending out a certified letter. But it is a tool, particularly for situations where we don't have good phone numbers or emails.
Any other questions? I just have one, and I think you might have touched on it at the meeting on Friday, but how is your staffing levels? How we provided you with some new additional employees, and how is that going? If you could just give us an update on that.
Madam Chairman, yes, we are working hard to fill those new positions right now. Unfortunately, we are in a state hiring freeze until July 1, I believe, and then we can, but that doesn't mean we aren't out recruiting, taking applications. And Holly's done a really good job with Trustland the last few months. She's managed to fill some key positions that have been open for a while, such as, the real estate analyst position for exchanges and that sort of thing. So we're making great progress in the right direction. And that's the other piece that we're hoping will help, is to have an extra set of hands, particularly in the grazing and agricultural lease renewal arena. I think that'll make a lot of difference.
Okay, great. Any further questions? All right, thank you so much. We appreciate you coming up and for all the information. We appreciate that. So with that being said, we've hit our time deadline. There is a bus outside to take us across the street to the ATEC building for lunch. I'm not sure how many lunches. Oh, we need to do public comment on state lands. Is there any public comment before we break for lunch? Any public comment? Seeing none, public comment is closed. Thank you for the reminder. So we will meet outside. There will be, you can either walk, or there's an EWC bus to take you across the street to the ATEC building for lunch. And then when we conclude lunch at 12:30, we'll leave, or 1:30, I'm sorry. 1:30, you have more than 15 minutes to eat. We'll leave for the tours, and we'll start it off the hook, which is down by Baumgars, if anybody that came in on 85. If not, we'll talk about how to get there. And then we'll conclude out at Bear Mountain Beef in Hawk Springs, south of Hawk Springs, on the cut across to Chugwater, where we'll have a barbecue, and Corey cooked some prime rib and brisket for you guys, and some pie, some apple pie. So that's where we'll conclude our touring and our supper. And so, yeah, that's what we're headed to do now. And I'm not sure how anybody that wants to tag along is welcome to. So, all right. And so we are adjourned for today, and thanks for everybody who came down. Appreciate it.